Good morning, everyone, and welcome to this meeting of the Planning Committee. Before we go any further, I'll ask the Democratic Services Officer to read the housekeeping.
Thank you. Please note this meeting of the Planning Committee is being recorded by the Council for live broadcast and will be published on the website for a minimum of 6 months. The meeting may also be recorded or streamed for live or subsequent broadcast by members of the public, although ultimate discretion in this matter lies with the Chair. For those in the room, please note if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point along Brady Road under the flyover. Finally, please ensure background noise is kept to a minimum and mobile phones and other devices are turned off or switched to silent for the duration of the meeting. For those in the room, this includes turning off microphones and turning the volume down completely on your laptops. Thank you.
Thank you. So first of all, introductions. My name is Marion Le Pedvin. I'm Councillor for Newtown and Heatherlands Ward, and I'm chairing this meeting.
Morning, I'm Paul Hilliard, Councillor for Highcliffe, Stampit and Muddyford, and I'm the Vice Chairman.
Matt Ginnett, Councillor for Topham and Branksome Woods.
My name is Patrick Canavan. I'm a councillor for Boscombe West and here as a substitute.
Peter Sidaway from Broadstone.
Brian Hitchcock from Hamworthy.
Bobby.
Lawrence Williams, also Little Down London. Councillor Joe Clements, Penhill Ward.
Councillor David Flagg, Burton Grange Ward.
Councillor Michael Tarling, Christchurch Town.
Councillor Kate Salmon, Moordown.
Good morning, sorry for being late. Councillor Felicity Rice, Oakdale Ward.
Thank you. And we also have several officers with us, working from the end of the table to my right.
Good morning, I'm Janie Berry. I'm the Director of Law and Governance.
Morning, Robert Firth, Senior Solicitor.
Morning, Simon Gould, Development Management Manager.
Morning, Wendy Lane, Director of Planning and Destination.
And you've already heard from Jill Holyoke, who's our Democratic Services Officer, who will be taking the minutes. And before we go any further, it's welcome to 2 of the 4 people sitting up here, Wendy Lane and Janie Berry. I can remember the Janies, sorry, who are both with us for the first time at Planning Committee. So welcome to both of you. So now we move on to looking at the minutes for the last meeting. Is everybody happy to?
Chair, can I just?
Oh, yes, sorry. Yeah. So, any apologies? And I know there are.
Yeah, thank you, Chair. So we've had apologies from Councillor Cameron Adams, Councillor Sharon Coral-Brown, Councillor John Challoner and Councillor Gillian Martin. Item 2, substitute members. Councillor Bobby Dove is here for Councillor Adams. Councillor Patrick Canavan is here for Councillor Carl-Brown. And Councillor Lawrence Williams is here for Councillor Challoner.
Thank you very much. Are there any declarations of interest on either item on this agenda? Councillor Gillett?
Yeah, I've been involved in a campaign in respect of the Heath for about 30 years. So.
But you will not be taking part in?
But I will be speaking to the committee as a ward councillor.
As ward councillor, but not as committee member?
Yeah.
Yes, for agenda item 7. Any other declarations of interest? No, thank you very much. So now we get to the minutes of the meetings on the 16th of November. Committee, are you happy that these be signed as an accurate record?
Green.
Thank you. So now we move on to the public issues. Anyone who is going to be addressing the meeting on item 6 will come to you later. We'll have the presentation first from the officer, and I call on Sophie Birch now, who will be online.
Morning.
Good morning.
Just share my screen. Can you see that okay?
That's fine. Thank you very much.
Okay, I'll get started then. The application in front of you today is at East Dorset Lawn Tennis and Croquet Club and Pool, and it seeks full planning permission to construct 3 new paddle tennis courts with floodlighting and a storage shed. It has been determined at Planning Committee, as there are over 20 letters of objection from residences within 1 mile of the site, contrary to the recommendation to approve the application. So the brought location, it's access via Saltburns Road and surrounded by residential properties to the south and the west boundary. The railway line is to the north and there's a school to the east. Also to the west is Ashley Cross Conservation Area. As you can see, it's outlined in red here and runs just behind properties along Saltburns Road and then around the railway line. The tennis court is not within the conservation area. So some site photos within the site, you can see the existing courts. This is down the access of Saltburns Road. This is when viewed from Worthington Crescent. And this is an aerial image of the site. So here's the proposed site plan. The proposed paddle courts will be situated to the east of the site and will replace 2 existing grass courts. The paddle courts will be slightly smaller than the existing courts, measuring approximately 9.8 metres in width and 20 metres in length. Galvanised steel mesh and tempered glass will surround the courts with a maximum height of 4 metres, and an acoustic screen is also proposed to the west of the courts. A shed is also proposed to the rear of the site, and as you can see, it's of a fairly small scale. So in terms of impact on the character and appearance of the area and Ashley Cross Conservation Area, the proposal is considered acceptable. The proposed court sits some 130 metres away from Saltburns Road, and given the intervening properties, clubhouse and car park, the proposals will not be prominent and would appear as a logical part of the existing structures within the site. Dense tree coverage and hedging will screen views from the school, and separation distances of approximately 50 metres and the presence of other courts and existing tennis paraphernalia will minimise any impact when viewed from Worthington Crescent. In terms of impact on neighbouring amenity, it is noted that a number of objections have made reference to the impact of noise from the proposed paddle courts. Following a series of amendments to the scheme and further technical reports, the Environmental Health Officer has confirmed they are content with the scheme with regards to noise, and mitigation measures are ensured through Condition 2, and a Section 106 legal agreement will be used to ensure the previous approval, which allowed for 2 paddle courts, is not implemented alongside this application. It should also be noted that the previous approval allowed for courts much closer to residential properties along Worthington Crescent, and this scheme would have a significantly lesser visual and physical impact on these properties. A number of objections also make reference to the impact of floodlights on neighbouring properties. It is, however, noted that the Environmental Health Officer has no objection to the floodlights, which are sited on the east and west sides of the court, not facing the properties along Worthington Crescent. I'll just bring up this, which shows the existing approval on site. So as you can see, they're much closer to the residential properties. So the highways team have raised no objection to the scheme, and the tree team are also content with the scheme, subject to a condition to ensure all works are carried out in accordance with the submitted tree reports. In terms of biodiversity, there are no bat records in sight. Nonetheless, a condition to ensure submission of the specification of the floodlights to not exceed 3000 Kelvin will be attached to any approval to ensure the protection of bats in accordance with PP 33 of the Pool Local Plan. So to sum everything up, the scheme would allow for the enhancement of an existing sporting facility located in an easily accessible area. It would provide economic benefits during construction and in sustaining the tennis club, and also result in social benefits for the same reason. It would not result in material harm to the character and appearance of the area or the setting of the adjacent conservation area. It would have acceptable impacts on neighbouring living conditions and would not detrimentally impact highway safety or protected trees. The scheme is therefore recommended for approval, subject to securing a legal agreement to prevent the implementation of the previous permission alongside this application. Thank you.
Thank you, Ms. Birch. So now we move on to representations, objectors and supporters of the scheme. Ms. Hallett, can you tell us who we've got?
Thank you, Chair. So in terms of objectors, there are 2. I have a written statement which I will read out first from Christopher and Leslie Stracey. Dear Planning Committee members, we would like to make a statement on the above for the planning meeting. We strongly object to the planning applications of the East Dorset Lawn Tennis and Croquet Club to erect paddle courts within their grounds. The positioning of the proposed new paddle courts and floodlights will negatively impact on the peaceful surroundings of Worthington Crescent, Mill Lane, Sultans Road and the Ashley Cross Conservation Area. It is a well-known fact, as evidenced by many online discussions in social media and local newspapers, that paddle courts are extremely noisy from the balls hitting the court walls, as well as from the players shouting and often swearing. Sound prevention fences are supposed to be erected to surround each paddle court. Erecting a 2.5 metre high wooden fence on the boundaries of the East Dorset Lawn Tennis and Croquet Club with Worthington Crescent and Mill Lane is completely wrong and will make residents of Worthington Crescent in particular feel like they are in a concentration camp. We feel that the potential numbers of people playing this known to be a noisy game on the proposed new paddle courts, particularly in the evening night with floodlights, will severely affect our mental health and well-being as our bedroom, living area and garden face the proposed development area. We also feel that because of global warming, prohibiting drainage by concreting over a large grass area is a very poor idea and should not be contemplated. We trust this statement will be made known to the Planning Committee at the meeting. Yours faithfully, Christopher and Leslie Stracey, Worthington Crescent Pool. The second objection is from Mr. and Mrs. Reeves. Mrs. Reeves is here, and if you'd like to come forward to the microphone to make your statement.
Good morning. Hopefully you'll be aware of how noisy padel courts are and the bad publicity it has gained when the courts are put up in residential areas, making the neighbours' everyday lives an absolute misery. In the 24 years we've lived next to the club, the lawn tennis has been played from May to September. Paddle would be played all year round from 8 o'clock in the morning to 9 o'clock at night. This is a relatively new game in the UK that is gaining popularity fast, and the majority of those wanting to set padel up are mindful in choosing places that aren't going to cause trouble to anyone else, as people are becoming more aware of the associated noise. For example, Paddle Stars in Southampton are in the process of building 6 padel courts, which are situated between the M27 and the airport, so nowhere near residents' properties. Others are on farms and golf courses, again, far enough away from residential properties to not cause noise or nuisance. In Europe, where padel tennis is well established, the guidelines for new courts require them to be at least 100 metres from residential properties. Ministers in Belgium have stated that padel tennis can only be played in an insulated building. David Lloyd Fitness Club in Poole have recently opened 2 new outdoor padel courts, which are at least 100 metres away from residential properties. We are only 50 metres from the proposed courts. We are retired and enjoy spending time in our home and garden, as do our neighbours. With 3 courts, there could potentially be 12 people playing at the same time. So we will be subjected to continuous noise that sounds like gunshots from a ball hitting the glass walls, and also what sounds like metal gate being slammed and ricocheted every time the ball hits the mesh walls. The club are aware of the noise that is going to be generated by the padel courts, as they have included a 4-metre high acoustic screen between the courts and the clubhouse to limit the noise disturbance to their members. However, there is no provisions for such a screen between the courts and our property, and we are 20 to 30 metres closer. The supporting documents to the application are riddled with errors and inconsistencies that we have commented on, which haven't been addressed. The 2 previous courts that got approved because of poor citing of site notices, so not enough people were aware of the application. Bournemouth have refused 2 applications for padel courts, mainly on noise issues, and we hope that you will follow suit, please, so as we and our neighbours can continue to enjoy this peaceful neighbourhood. Thank you.
Thank you, Mrs. Reeves. And we have some supporters wishing to speak.
We do, Chair. So we have Mr. Giles Moyer and Mr. A. Crow, if you'd like to come forward. Thank you.
Thank you for the opportunity to speak in support of the application on behalf of the East Dorset Lawn and Tennis and Croquet Club. As detailed in the committee report, permission already exists for the construction of 2 paddle tennis courts. These courts are sited towards the club's southern boundary, close to the properties in Worthington Crescent. This application seeks to relocate the courts to the centre of the club. The alignment of the proposed courts will allow for 3 courts to be provided. As acknowledged in the committee report, this current proposal will have a reduced impact on neighbouring properties when compared to the approved application, representing an improvement to the amenities and outlook from neighbouring properties. The applicant has liaised with the Council's Environmental Health Officer and has designed an acoustic screen in addition to the screening that surrounds the courts, which will reduce lateral noise emissions and ensure that the proposal, in terms of noise generation, does not have a detrimental impact upon neighbouring properties. As detailed in the committee report, the Environmental Health Officer is now content with the proposals. The proposals will enhance an already existing community facility, improving the sporting and recreational offer available to local residents, and provide much needed facilities in a sustainable and accessible location, and as such will comply with the aims of policy PP26 of the local plan. The site, as you've seen from the presentation, is located adjacent to the Ashley Cross Conservation Area. The proposal will have very limited visitors from outside of the site, and any visitors that are available will be at the proposed courts set against the existing tennis courts, i.e. they will not appear out of character or detract from the setting of the conservation area, and as such the proposal complies with the aims of policy PP27 of the local plan. The existing tennis courts sited to the north of proposed paddle courts are already floodlit. The proposed floodlights for the paddle tennis courts will provide directional lighting and avoid light spill. Given that there is already floodlighting within the club, the proposed floodlights for the paddle tennis courts will not be harmful to the character and amenity of the area. In conclusion, I hope that you're able to support the application and recommend it for approval. Thank you.
Thank you. And Mr. Crowe?
Thanks. East Dorset Lawn Tennis and Croquet Club is a public health and sports charity based in the heart of Ashley Cross Pool, whose objects are to promote sport and healthy recreation to young and old throughout the local community. All the club's trustees manage the club on a voluntary basis. I'm a trustee and treasurer for the club. The club was established in 1909 and the current sporting facilities include 5 croquet lawns and 19 tennis courts, of which 3 will be replaced by the paddle courts. Bridge and table tennis are also available. The club is well known in the local community and hosts annual firework event with up to 303,000 visitors. The community and general public also has access to the clubhouse containing bar, cafe, function rooms and changing facilities. Our proposal is to construct and operate 3 outdoor paddle tennis courts to be available to all BCP residents and members of the public. In consultation with the planning officers, we have revised our initial plans to position the courts in the best possible location away from residential neighbouring properties to avoid adverse impacts on our immediate neighbours. Paddle tennis, a relatively new sport in the UK, is currently the fastest growing sport in the UK and Europe, primarily due to the fact it is an easy game to learn and enjoy. The health benefits are both physical and mental through social interaction of enjoyable play in close proximity to others from a much less technical game than tennis. We believe that the easier accessibility and social aspects of paddle tennis will increase participation in the BCP community by getting more people physically active and playing sport, particularly those people that are not known to be less likely to take part in sport and physical activity, thereby improving the well-being, welfare and public health of BCP residents. The sport has less barriers to entry and makes it more accessible and fun. The nearest publicly available courts are a 90-mile round trip away near Winchester. When playing there, we have found other players from BCP and other parts of Dorset, including as far away as Sherborne and Shaftesbury, who make the trip just to have the opportunity to play. We hope you will be able to approve our application.
Thank you, Mr. Crowe. So we move on now to our debate, starting with any questions members may have for the presenting officer or maybe any other planning officers. Councillor Gillett.
Yeah, one of the residents suggested that there was very little sound screening between the paddle courts and the the properties. But it seemed from the presentation that there was that had been taken into account and was sufficient. Can we just have a update on that from Elsa, please?
Sorry, what exactly is the question? Is it just if the mitigation measures are sufficient?
Yeah, essentially the resident was saying that there are no, I think essentially said there are no mitigation measures between the paddle court and the residential properties, but there are some between the paddle boards and the clubhouse. Just looking for a clarification on that.
Yeah, that's correct. Our environmental health team are content that the noise won't constitute a nuisance. If I could bring my colleague Paul Barker on, if he wants to add anything to that, Paul.
Hi, is this working?
Yeah.
Sorry, there seems to be a bit of a delay there. Firstly, thank you, Chair, for letting me speak. Can I first address the questions about acoustic fencing? Padel tennis is a movable noise source, so acoustic fencings don't really work that well with it. Besides that, acoustic fences will work better at the noise source rather than at the receptor. The fences that Mrs. Reeves on about, where she thinks that we put them in place to try and protect the paddle tennis clubhouse, that wasn't the case at all. We put that in as an extra to help with the propagation of noise breakout from the entry and exit side panels of the courts. So literally the acoustic fencing, the panel may wish to add some, but it will be better at the noise source. The noise levels that paddle tennis will create over the distance between the noise source and the nearest receptor are good enough that it's not going to cause a nuisance in our opinion.
You happy, Councillor Gillett?
Yeah.
Okay, and Councillor Tarling.
Yeah, I sort of agree with the acoustic thing. The point that was made about nuisance and swearing. Now, I played at other tennis venues, as in not paddle tennis. I've never played it, and I've not witnessed a great deal of swearing. I'm just wondering if the club has a policy about behaviour and use of language on the tennis court. I think this would apply to the whole club area, but I agree. I wouldn't want to hear swearing from my back garden. I've not witnessed it on a tennis court.
Is there a question in here?
There is. Do they have a policy about use of swear or foul language?
Can you answer that, Ms. Birch? Or anyone? That might be sensible in this case. Yes. We don't usually have the applicant speaking a second time, but when it's a specific question like this, it seems appropriate.
The club does have all these procedures and complaints procedures in place. And as far as I'm aware, we haven't had any recent complaints at all involving bad language. And these courts are much further away than the existing grass tennis courts that really are on the boundary of the neighbours.
Happy, Councillor Tarling?
Yeah, I wanted to make sure before I make my decision that we've addressed all the points that the objectors have made, and that's the one that I don't think I've read in any papers have been addressed. That has been addressed. Thank you.
Thank you. Any further questions? Councillor Tidaway, then Councillor Hilliard.
I'm also
Peter.
Sorry, yeah, we're out of practice, aren't we? Yeah, a little bit concerned about the noise and wonder what comparisons have been made to other paddle tennis facilities, if there aren't any in locally, what the officers have compared it to make sure that they're comfortable that it won't cause a problem.
I would say that we assess each application on its merits as far as we are concerned. Environmental health are content that the noise won't be a nuisance, so we've taken their advice and we're content. Again, Paul, I'm not sure if you have anything else to add or.
Just a quick one. Obviously, I would obviously give in to the experts from the acoustic firm with Clark and Saunders. They're far more experienced with this sort of thing than I am. We scrutinise their reports when it come in and we check their calculations. Under the World Health Organization guidance for noise in an outdoor area, as in a garden, we would aim for 50, but 55 is acceptable. We did calculations that if all 3 balls were to hit all 3 rackets at exactly the same time, that would create 68 decibels. Over a distance attenuation of 50 metres, that would be 34 in the garden, which is well within WHO guidance regulations. I hope this sort of puts people's minds at rest on this.
Follow up, if I may. Did you say if 3 balls hit 3 rackets?
3 rackets, 3 paddle tennis things. I mean, that's just words, really, isn't it?
Because I don't think rackets were the problem. I think the issue that was raised was the ball hitting the walls of the court, not the rackets. So I think that's probably the thing. And I guess my concern is this is fairly new. I don't see much evidence that there's been a lot of research into some of the newer things that are going on with paddle tennis to compare it. I don't know if it's right or wrong because I don't see a great deal in front of us to confirm that, to be honest.
The acoustic consultants would have modelled that at the time of their survey.
But we can't see that.
What, in the reports?
I don't see any decibel limit reports from other paddle tennis courts to compare to it. Would be useful.
Well, they would already have these sound levels that were created by it. They do noise modelling on their CAD software. I think the graphs are there to show where it would be affected.
I don't know. I'd be interested in what others think about it. I'm not sure that I'm seeing the evidence that's being talked about here. I don't see. I mean, you point me at the report where it says it, if that's an issue.
Bear with me.
So, Ms Birch, have you included anything on noise in the report that you would point us to very quickly? You're muted. You're muted.
I think the detail that the councillor is after is more likely to be in the tactical noise reports.
And you took those into account when you drew up your report?
Well, yes, environmental health were satisfied that the noise wouldn't constitute a nuisance. So they were satisfied, we were satisfied that as our statutory consultee, they were content.
Okay, thank you.
I guess the question is, what did they do? I mean, I'm not saying it's right or wrong, but I'd like to know what they did, really. That's the issue.
To be honest, I think that's beyond our remit. The experts in environmental health have looked at it. They're happy. I think we've got to trust their judgment. We can't go into detail on every point on every planning application. We are not experts. They are.
I get that. I think this is new, and I think that expertise should be shared.
So, Councillor Hilliard.
Thank you, Chair. A few questions for Mr Barker again, please. Could you just explain what 36 decibels, what is that sound? What would people be familiar to hear? Thanks.
Okay, it's widely known within planning terms that we would look for noise outside a window at night from any plant, machine, or any noise source not to be above 35 dB. So you then allow a -15 reduction for an open window for ventilation. So we always work as per the WHO guidance, the World Health Organization guidances for noise levels. The paddle tennis courts, as per the noise modelling done by the experts, which are Clark's owners, have demonstrated that this will not be a nuisance there. Our calculations we did on top of that prove that the noise levels just won't be an issue.
So will it be like a hum of a air conditioning unit, or what type of sound would it be? That's 36.
You would hear a very soft thump. That's all it would be.
Okay, and
it'd be easily masked by passing traffic.
Right. It's probably not open. It's probably members only. But West Hants have a paddle board court. Have you had any complaints from there at all?
There have been complaints, but not recently over paddle tennis. No, I think most of the complaints are about future planning applications for further courts.
Right, and obviously your team deal with noise. So if the noise was higher than expected, what would be a sort of a comeback
If in future, if we actually attended and thought they haven't achieved, realistically, they haven't achieved what we thought they would, we can always put an abatement notice on the club to say they can't carry on until they carry out further attenuation methods.
Okay, that's
It's not,
very
it's
useful.
not the end of it. We do have other legislation we could apply if it does turn out to be a nuisance.
Yeah. Okay. Thank you. That's great.
Councillor Canavan. Sorry. Yeah, it's not Councillor Canavan.
Do we know what time they're likely to stop the last people playing the game?
It is in the conditions,
It is.
which I think was 9 o'clock.
Yes, that's right, 9 o'clock.
Is that to end the game or is that to have the last people to go and play?
I took it to close the courts, but
Close the court, yeah?
Yeah.
Yeah, they can't be used after 9 p.m.
Okay, thank you.
Councillor Dove.
I'm really sorry to labour this point. Sorry to labour the point. I think it's just understanding the impact of the noise. So it says here, and I appreciate that obviously the noise has issues have bounced back to and forth between environmental health and the applicants a few times. It's obviously been established, although we have not been party to into the concerns that were raised by our environmental health officer. But what it does say is about to put conditions in regarding mitigation. And I wondered, therefore, if you could explain what those were, what's been agreed, what those conditions would look like in order to reassure the panel, any sort of features that you've put in so that our concerns could be relayed on that point, please.
Yep, Paul, if you could hopefully answer that one. It's just what mitigation measures are ensured to mitigate the noise.
Again, the best attenuation you can achieve is over distance, which was the reason we moved the courts further north. Of course, the more distance you get from the noise source, the less impact it's going to have. We put in the mitigation for the breakout of noise, so we asked for the acoustic fencing. We asked for the courts to be turned north to south, with the entry and exits being east and west. And then we asked for acoustic fencing at the side of those so that any breakout noise from the sides would be dampened down as well.
Thank you. Any further questions or shall we move on to debate? Okay.
Thank you very much. That is really helpful. So in paragraph 56, where it says, is therefore considered that with the attachment of a condition to ensure the implementation of measures outlined in the acoustic report, is that what you are referring to then, what's just been outlined to us just now, or is there anything on top of that?
No, we wouldn't require anything on that because it's the distance, the attenuation over distance now is sufficient to stop the paddle tennis courts causing a nuisance.
And I could follow on to this. Those measures that are outlined in the reports, that report forms part of the approved plan condition. So through that condition, they have to implement those measures. And then on top of that, we'll also obviously have the legal agreement, which will prevent both the existing permissions on the site being implemented together.
Councillor Salmon.
Thank you, Chair. Different topic, just on the issue of drainage, because I'm aware that that was something that some of the objectors had raised. I know there is a paragraph in the report that covers it. I just wanted to ask a question. So my understanding of this application is that it's grass court that will be converted to hard standing. And within policy, because it's not a major development, there's no requirement for sustainable drainage systems to be used. However, it would surely be best practice to attempt not to just pave over grass with hard standing, which does have an impact on drainage and can increase the risk of more surface water flooding if there's heavy rainfall or extreme weather events.
Question?
Yeah, so my question is it possible for us to put in any kind of condition or recommendation to the developer that be incorporated into the final designs?
Ms. Birch?
We could condition it to ensure sustainable urban drainage. However, I would potentially have concerns whether that's reasonable because it is in a flood zone 1, so it has the lowest at the lowest risk of flooding, and also it's not required by policy. But if the committee felt it was appropriate, they could.
Okay, thank you. Any further questions? Okay, open it up to debate. Who wants to kick it off? Councillor Tarling.
Yeah, I I'd say I have played tennis. I've not played this before. I have seen it before, and I've seen the rackets or the bats that are used. I think from when I've seen it played, it creates a slightly different sound to that of a tennis ball on a traditional tennis racket, but it is a tennis racket, and yes, it will bounce off the rear wall, and that's how I understand the game is played. I had a quick look at the LTA guidance on it. I take on board what the applicant has made about it being a fun, accessible sport. For my part, I do hear what the objectors are saying about the noise, but there is noise during the summer from people playing ordinary tennis, from hitting an ordinary ball, and anybody goes watches tennis played or plays tennis themselves, there is noise. We'll remember Wimbledon and certain tennis players grunting, and that has been raised, yet sort of natural expressions of energy. But for my part, it's like a children's playground. The noise is only a nuisance if you perceive it to be so. And that is in the ear of the beholder somewhat. And for me, hearing children playing a playground or people playing tennis or the nice hit of leather on Willow at a cricket club is part of what makes our society. And the idea that a slightly the same ball hitting a slightly different racket is by any means detrimental over a traditional tennis court, I think is nugatory. I think the balance of creating a new accessible form of sport for young people to play is highly commendable, and I'm pleased to hear that the club is accessible to all to come and play the sport, unlike the David Lloyd Centre where you have to pay quite high membership to go and play sports. So regarding the drainage issue, I mean that is somewhat down to the operator of the facilities, because I don't think you can play this underwater, and as long as there's no positive drainage to the public sewer, which I wouldn't imagine there is because it's not detailed and it's not been picked up, the water would just run off the courts into the surrounding area, and that wouldn't necessarily impact the wider flood area. It's sufficiently far away from neighbouring properties to not, in my opinion, cause a flood risk to neighbouring properties. So I'm supportive of this scheme, but I'd like to hear what other councillors, members of this committee think. Thank you.
Thank you. Councillor Clements.
Thank you, Chair. Personally, I love the idea of this fantastic facility being offered to our community. I'm a big fan of progress. I think we need this, our towns need to progress and develop and improve and get more modern. But I'm very, very concerned about the noise levels on this, in particular for the residents of Worthington Crescent. We don't know for sure exactly how it's going to impact people so close, and I think the sound is going to be quite different hitting a hard surface than it would be hitting a grass surface, and it's one of those situations where until you're put in it, you don't know what the impact might be. So I'm a little bit nervous. If those courts up in Worthington Crescent were moved further in, I wouldn't feel quite so unsure about it.
Thank you. Councillor Sibley.
I'm familiar with East Dorset Tennis Club, and it's a fantastic facility, and I'm very supportive of the addition of this sort of feature. And I think it's great, as was said, that it's available to the public without having to join somewhere expensive. I am concerned that I don't think there's enough evidence, as you know, and I wonder if we could put a condition on that says over a certain level, the level that is believed to be where it's at 36 or whatever, that if there is recordings over 36, that something else has to happen. I don't know what, but someone at least has to get involved and say, maybe we need to have another look, because it is uncertain, as Councillor Clements said. And I think it's the uncertainty, not anything else, that makes me doubt it, because I think it's a fantastic facility and a great addition to it. It's only the uncertainty that causes me doubt. Other than that, I'm completely supportive of it.
Thank you. I'm just wondering, in view of what the environment officer said about noise and monitoring, whether that condition would actually be necessary, or whether it's the sort of thing that will happen anyway. If there are complaints, I mean, as soon as there would be major complaints that it's unacceptable, they would monitor. They would come in and look at it. So can we have a view on that? Am I correct or am I not correct?
Hi, Chair, is that directed at me?
Yes, please.
Actually, if the residents were to make complaints, we do have the facilities to go out and take readings and measurements again. It's unrealistic to expect that the noise won't be above 36. As I've already as I've already said earlier on, the WHO guidance for noise in an outside area is 55 in an urban environment. So you'd have to look at noise above 55 before we'd even look at it being a nuisance. But we can take readings to find out what the noise levels are.
Yeah, but if there were complaints, we would
investigate. Yes, we would investigate. Yeah.
Thank you. Anyone else?
Sorry, I'll just follow up on that. I think it's the basis of the complaint and the basis of the investigation. So if there are complaints and they go along and do readings and they go, oh yeah, it's fine, but there's no baseline against which to mark that complaint and that reading, and that's why I was suggesting maybe some sort of condition that gives it a baseline. That would be all I'd be looking for.
Can you add anything about the baseline, Mr. Barker?
I think we've got to be guided by the World Health Organization guidance. Bear in mind, during the day, it would be difficult to extrapolate the noise just from the paddle tennis from what's actually going on around it. For instance, a truck going by on the road would easily mask the noise that the paddle tennis is creating. What we would need to do is take what's called an L-line, it's a 15-minute measurement over what the average sound level is over, say, 15 minutes when the paddle tennis isn't taking place, and then take another 15-minute reading when it is taking place, and we would look at the difference on that. If there's a plus 10 decibel increase, then yes, we would look at it as being an issue. But as per the measurement that's already been created and modelled by Clark Saunders, that's, in our view, that's not going to be an issue.
Thank you. Yeah. Mr. Councillor Gillett.
Yeah, I played paddle tennis and a bit before, and my thought with it is that I've actually also played croquet before, which is being played in the club there. I've actually once played it down there. When you hit a hard surface against a hard surface, it makes a lot more noise when you hit a hard surface against a softer surface. So I would have thought the decibels from a croquet mallet are going to be, which is already being played there, is going to be higher than the decibels from a paddle tennis.
Any more? Councillor Tarling. Oh, let's have Councillor Flagg first because he hasn't spoken.
Thank you, Chair. I'm comforted by the assurances from the Environmental Health Officer, and I'm happy to support the application.
Thank you. Councillor Tarling.
Yeah, I'm sort of going to go over again. The decibel rating is logarithmic. For those of you that might want to cast your mind back to your days doing maths, so the reduction from 55 to 35 decibels is not linear. It's actually logarithmic in its scale and how decibels, and that is a very significant drop. And environmental noise, when you do an environmental study, you do measure background environmental noise, and as I think our environmental health has advised, during the daytime, it will be masked by so many other noises, environmental noises, that will increase over this. Hence, there is a restriction at 9 o'clock, because at 9 o'clock, when the traffic dies down, you would be able to hear people playing it, but you would have to be outside in your garden listening for it. With a closed window, you won't even be able to hear this. I'm absolutely sure of that. However, under the Control of Pollution Act, Section 60, which is the piece of legislation that our environmental health officers use about nuisance, yes, they will go and measure it. But as our officer has just said, the chance of exceeding the 55 decibels with this, when it's only 35 outside the court, and it's 100 meters away, or whatever the distance is, I can't remember what it was, but such a distance away, is very small. You will be able to hear it, but it's going to be like being next to a cricket ground or any other sports facility. It'll be a slightly different sound from. So I appreciate the anxiety this has caused for residents, that there will be a different sort of noise, but I don't think it after the operation of this facility that it will actually present a nuisance to the residents. So again, I'm just the difference between nuisance and being able to hear it. People don't have a right to not hear anything. We don't live in a soundless world. We can hear the traffic going outside here at the moment. That's what it is to live in a town or a city. You know, it's one of the noises you get, and it's I think the listening to people having fun and playing sport, it is not a negative thing. I don't even mind hearing the stadium, you know, the Vitality Stadium, when a goal gets scored and hearing cheering. Sometimes that's okay, you know.
Thank you.
Thank you.
And among all the background noise, it is next to a school, so there will be noises of different sorts coming from the school, presumably. So, I didn't hear what somebody said something. I'll pretend I didn't hear that because I think I did. Any other comments? Is someone willing to? Oh, let's go.
Yeah, Chair, I don't know if it would be useful. I've just obviously been listening to the questions and the debate on the various topics that have been raised, and if I can add anything to sort of give members more clarity, then I'm happy to do so. You heard obviously through the presentation from Sophie and from the deputation from the applicant that there's an extant approval on this site already for 2 paddle courts, and those paddle courts are located towards the southern end of the site, so you know, much closer to the Worthington Crescent properties. So you know, that is a material consideration. This application, obviously, yes, it adds an additional paddle court, so we go from 2 to 3, but obviously it moves them further to the north, so the distances are greater. And as you've heard from Paul from Environmental Health, that feeds into how we now consider it to be more acceptable in terms of noise pollution. There's obviously some questions from councillors around the technical side of the noise assessment, and I jumped online and onto the record, and I found one of the technical notes that supports the noise assessment, and obviously it considers that fallback position. So actually, there's actually a reduction in noise from this application because the paddle courts are further away. So they say it's about a 5 decibel reduction compared to what residents would experience if the approved scheme was implemented. There's also a requirement for a Section 106 agreement on this application if approved, which would effectively remove the rights or the scope for the applicant to implement their extant permission. So we wouldn't end up with a scenario of 5 paddle courts. So again, in terms of noise, there is a technical assessment that sits behind this application by people with the requisite qualifications. And actually what the conclusion is from the professionals is that overall there'd be a noise reduction stemming from this application if implemented. There was another question from Councillor around drainage. And I think that Councillor Tarling made some very valid points. I think the only other comment I would say is that obviously this is flood zone 1, so it's low level. But the other thing to remember is that the paddle courts are surrounded by a lot of grass. So there's natural drainage happening anyway. And if we had a really bad rain event, then you just wouldn't be able to play paddle tennis or tennis. So, it would just be a case of natural drainage into the land. And there's a lot of grass on this site. Finally, Chair, just to hopefully assure members again that condition 2 lists all what be the approved plans and supporting documents, and that includes the noise assessment. So if approved and implemented, there was any noises that were exceeding what's been set out in the technical specification, and as Paul said, Environmental Health would have legislation to start monitoring that, and they'd be in breach of their approved documents.
Thank you. Very helpful. So if there's no further, Councillor Tarling. Good. That was my next question. I was going to do it myself if nobody else had. Thank you. So Councillor Tarling is proposing we accept, presumably. Proposing
with the
with the conditions as specified.
Sure. A lot of people are guessing what I was about to say. That we accept it as laid out in the officer's report with the conditions, and yes, that was to the point of the section 106, withdrawing the other application. So so long as that's in there, I propose that we accept it as laid out.
Thank you. So we've got a proposer. Have we got a seconder? Thank you to Councillor Flagg. So now to the vote. The motion is that we accept the recommendation from the officer to approve this application with the conditions as set, including the 106 agreement, which is in the conditions. Those in favour, please vote now.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
Any against?
None.
Any abstentions?
1.
Thank you. Thank you very much, everybody. I suggest we have a quick break now. We've been going nearly an hour. Give us time to rearrange. People who are leaving can leave. People who are, if there's anyone else to arrive, I don't know whether there is, to give them time to arrive. So if we take a 10-minute or so break. So welcome back to the second part of today's planning committee. This is not an application for us to judge, but to look at an update on the land south of Gillett Road, Talbot Village Pool, otherwise known as Highmore Farm or the Innovation Quarter. It goes under many different names in the local area. So first of all, I'll be handing over to. Oh, sorry. First of all, Councillor Gillett wants to make a statement.
Yes, so if we finish with sort of the procedural side of that, then I'm going to step out and I will reserve my right to speak as a councillor.
Thank you. Mike. Microphone, not a councillor called Mike. But I hand over to Councillor Mike Tarling.
Thank you, Chair. As I've just intimated, I wasn't involved in the original decision making because I didn't attend the full site visit, so was precluded from doing so. I did actually view the whole of the decision process, but as I wasn't involved in the original decision making process, I won't be involved in a vote whereby we are deciding, if it comes to it, on the actual material facts of the planning application, but I do wish to be present as a member of the committee on the actual procedural part of it. So I won't vote, but I will be part of the procedural part of this.
Thank you.
I've taken advice from our advisor on that. Thank you.
Councillor Rice.
Thank you. Yeah, can I just get clarification on behalf of Councillor Adams, who's present in the room but not sitting in the committee, just with regards to who is able to be present and be part of the debate, because there was confusion around subs that were present on the day could come along as well as the original committee members. So if we could just get clarification around that.
Yes. I'll hand over to Robert.
Thank you, Chair. I'll do my best as to what I think I understand the question. I'll do my best to try.
So the ultimate aim is whether Councillor Adams can come and sit here or not.
I think the problem, and I'm just trying to find the part now. I think the problem with Councillor Adams now engaging is because the committee's already started and we've already had one item that's being considered. Substitutes are brought in to cover the whole meeting, and because we're partway through the meeting, I think that's now the problem. Is he couldn't engage on that basis at this stage now.
Yes, I wondered.
And his substitute is present and continuing.
Yes. I think there may have been confusion that he didn't think that he could be on the committee at all. So that's why he wasn't sat here.
But as a councillor, he's welcome to stay and listen.
Yeah. It was just to get full clarification.
The question I had was when
You could, but it would mean you would be, the committee would be one down in numbers because you. It would have, but it hasn't happened. Nobody's acted that way.
So I think it will inevitably depend on individual council situations. So I can't. It's hard to make specific comments. What I'd say generally is yes. The position that's been adopted is there's a lot of the various provisions in the constitution that say if you're engaging in these sort of applications, you should be there for the whole of the application and debating about it. And if you're going to vote on the item at the end, that's certainly something you should therefore have in mind in deciding how you're going to sit and engage with it. So that is, I suspect, that's the basis for the original thought that was provided. If you weren't party to the original discussion, then there's a difficulty potentially in you engaging now because of the wording of some of the provisions in the protocols. So that's the position, but that doesn't stop you sitting there.
No,
I don't need the bond. It doesn't.
there's an issue about debating and engaging in debates and engaging in the voting. To be honest, I'd have to revisit all the particular wording of the individual constitutional provisions to be specific on the fact, but I think primarily the problem would potentially might sit on the debating side, and it would certainly sit on the voting side. That's where the vote issues would fall. But as it happens at this moment in time, I think because you haven't engaged in this part of this particular committee, you'd have difficulty now substituting back in.
Yeah. So can I clarify, the people sitting on the committee today, with one exception, we've just heard, are the people who took part in the original debates. The same, if councillors had to be substituted, the same people are substituting for the same people. The only exception is Councillor Tarling, who has already said he will not take part in the vote. Since this morning session, we've been joined by two other officers, so I'll give them a chance to introduce themselves.
Hi everyone, Frances Summers, Senior Planning Officer at BCP.
Hello, my name is Monika Kwiatkowska. I'm the DM team leader in BCP and also case officer for this application.
Thank you. So now we move on to the business in hand. The item will be introduced by Miss Lane.
Thank you. Francis, can you put the presentation up for me? Okay, thank you. So for that slight delay. As explained on this initial slide, this is an update on the planning application that was considered at Planning Committee on the 2nd of October. It's a major hybrid application for a combination of full elements related to the hospital and then outline planning application for the provision of employment, healthcare and university related space for the and including aspects with a Heathland support area for the innovation quarter. Next slide, please. So this is just the map of the site, just to make sure that we all know what we're talking about. Next slide, please. So what this slide is just to give you a bit more context. So there is a sequence of events. Planning committee meeting, as I alluded to earlier, took place on the 2nd of October with a resolution to refuse. Following that, there was a decision that legal advice was sought on that resolution. Planning committee subsequently agreed that external expert advice be sought. That advice was sought. That did take a lot longer than was anticipated when that originally went to market. That was because there wasn't a lack of interest from consultants to do the work that was required. That then led towards that was a key reason why the planning committee on the 14th of December was cancelled, because that information hadn't come back because of the late commissioning of that additional advice. Prior to the decision to cancel that committee meeting, however, the applicant submitted a non-determination appeal, and obviously we are now today, you are being provided with an update on where we are. Next slide, please. So the resolution to refuse at the 2nd of October was for 3 reasons. Well, related to 3 policies in the Poole Local Plan, which was adopted in 2018 and is still considered to be an up-to-date plan. And as obviously as members understand, planning decisions need to be made in line with the development plan unless material considerations advise otherwise. That's set in planning law. So a key aspect is that fundamental around, say, the development plan. Next slide, please. So we are having to consider how we move forward in relation to a non-determination appeal.
Whilst the planning committee made a resolution, a decision notice was not produced, as the detailed wording for the decision had not been produced by the head of planning in consultation with the chair. So as we've advised, the non-determination appeal was lodged on the 4th of December, as no decision notice had been issued. The planning inspectorate will now decide the application, and we received a start letter on the 8th of January setting out the timetable for the appeal. As set out in the report to planning committee in paragraph 6, irrespective of whether an appeal results from an appeal against a formal refusal of planning permission or appeal against non-determination, it is a sensible part of an appeal process for the council to review its position in relation to it, including reasons why appeal should be taken forward, etc. This is quite important because it's obviously material for where we move forward. Can you give me my next slide, please? So we are on a really tight timetable. So even though we only received the start letter on the 8th of January, the inspectorate has currently determined that it wants to do the public inquiry at the end of April, and they're currently scheduling that for 4 sitting days. What that means is by the 12th of February, we need to submit, or there needs to be the submission of the local planning authority statement giving full details of the case that will be put forward to the inquiry, including any documents, maps or plans that the local planning authority intends to refer to or use in their evidence. We also need to submit a copy of the completed agreement statement of common ground, listing all matters that are not only agreed but also confirming where there is disagreement. This is quite an important process, and it's particularly challenging in relation to this planning application and the fact that it's an allocated site. Next slide, please. Okay, that's fine. So very much that's where we are at the moment, is setting that context for the next component.
Thank you. Mr. Perth, have you got anything to add at this stage, or?
I don't think so, Chair.
Thank you. Thank you. So is everybody, our committee members, clear on where we are now from that presentation? Thank you. I take that as a yes. Good. Thank you. So now we have a resolution. We are asked to consider a resolution to exclude the public and press. Could I have someone to explain the reasoning for this, please?
Sorry.
I was hoping you would explain, or you or somebody would explain the reasoning for considering going into exempt session.
So, Chair, if I may, the committee is absolutely right at this moment in time within its rights to debate the merits or not of the information that has been outlined by Wendy in terms of next steps, and also debate the information that's contained in the public report supporting this committee, which every member has in front of it. If, as part of that debate, you feel that there is a need to go into exempt session, or which essentially is to exclude the press and public from the debate in order to debate the contents of the supplemental agenda, which contains exempted material, you can do so at that stage, subject to the approval of a motion to go into the exempt session. So before taking that vote, if members want to have a public debate now on the merits or not, as detailed within the report, you're absolutely free to do so. Alternatively, Chair, if you want to have the recommendation now about going into exempt session and then rely on it at a later stage, for example, if it's passed, you can do that. But I would strongly encourage that members should be able to have a public debate on the contents of the public report first before consideration of whether or not to go into exempt session.
Okay, thank you. Councillor Tarling.
Yes, thank you. Thank you, Madam Chair. Just to clarify, because I know there's a bit of debate prior to us starting a session about my role here, so I won't be involved, as I said again, in the actual discussion of this, but regarding the exempt session, I think we do need to have some debate here before we access the legally privileged information that we have received, that's not restricted on councillors' papers. I think there's if we don't have some debate at this point about where we're going to, I think that the public and the press will probably say, well, hang on, it's all done behind closed doors. So it's going to be very difficult to find that cut-off point. But I suggest that if there's councillors here that have something to say that doesn't directly relate to the contents of our restricted items, that we do so at this point. Thank you.
Mr. Firth.
Chair, just to make one point. So, and just follows on from what the monitoring officer was saying. If members opt to go into private session now, what it doesn't do is prevent them coming out of private session afterwards.
Yeah.
And so, in certain respects, members may alternatively feel they might want to get that information up front and then have a debate afterwards, having got that information, but it's entirely a matter for them.
Yes, I mean, if we do go into exempt session, we will come back into full session to outline what our decision has been. Yeah. Somebody said something.
I did.
Councillor Dove.
Thank you. I don't think we should be making the decision in exempts. My understanding is we are going into exempt to hear and discuss and understand the legal privileged information. It is not then to have a debate in private and come out and explain our decision. All of that debate, as far as I'm understanding, thank you, Mr. Firth, for nodding there, will be done in public, and it will need to be done in public, but we're only going into exempt to hear that legal privileged information and make sure we understand it. I'd like clarification on that, please.
Chair, just to be clear on that. So yes, that's what I would have anticipated would have happened. But to be clear, when you go back into public debate, if you've opted to go into exempt session, what you shouldn't be doing is debating the information that's been discussed in private session. You can obviously draw your own conclusions from that, but you shouldn't be and must not debate in public session what's information that's been provided to you in private session.
Chair, if I may add, it is after a period of exempt session, it is always good practice to go back into the public element of the meeting to simply notify the members of the public who are watching or who may wish to come back into the room of the recommendation that is made. So, for example, you've got a recommendation before you in the report, but it is always good practice to put the recommendation in the public domain wherever possible, because the public have an awareness of the matters being discussed. Depending on the debate, some of the elements have to take place in exempt session, but it is always wise to conclude the meeting in the public forum so that members of the public are aware of the recommendation that the committee is ultimately going to make, because that is a public record.
Clearly.
Because that is the public record. It aids my colleagues in democratic services in putting the minutes together, and the minutes are the public record of the outcome of the meeting and the decision made by the committee. So
that was always my intention, but
absolutely.
I didn't explain it very well.
And as Robert has very eloquently explained, that the issue is that when you go back into public session, you can't then disclose the information that you've considered in the private session. So it's a very careful judgment on your behalf about how you put that information forward to ensure that there is clarity and transparency for members of the public.
Thank you. So, lost it again. So, I suggest perhaps we have an explanation now of the content of the published report, the publicly available published report, and then we talk about whether we are minded to go into exempt session or not. Okay, so
Chairman, I would say I think it's up to members what they want to do, but what I'd say if members want to have the legal, obviously they're suggesting you go into exempt session to receive legal advice. If they wanted that in advance before they discuss anything else, it's a matter for them, or they have to discuss it in advance. That's fine. So it's a matter for members in that sense.
So, any thoughts, Councillor Tarling?
Yeah, I can see one of my councillors opposite is a little bit uncomfortable, and I'm more than happy for him to reply to this. But for my part, and I think you've touched on it, I think if we had a debate and not referred to the exempt elements, then go into exempt session, and then come out of exempt session, but with a big handful of caution to remind members not to discuss what was in the exempt items, to either then carry on the debate, but again, being very mindful not to discuss exempt items, which is going to be very difficult, or we discuss the exempt item and come to a recommendation. And as our officers have advised us, we do the recommendations in public session afterwards.
Yeah.
That I think would be easier for a lot of members rather than having the opportunity of saying something that would be legally privileged and prejudicial to our position in the
Yeah,
appeal.
that was my feeling as well. As I say, I obviously haven't outlined it clearly enough because you're actually saying the things that I was trying to convey earlier on. So, members, do you want to hear a presentation on the publicly available report, and then we will talk about whether to go into exempt session? Or do you want to go straight into exempt session? I'm not suggesting we decide now not to go into exempt session at all. We'll decide that a bit later if it's appropriate. Councillor Dove.
I think, Chair, you've actually just nailed the crux of it. We may not have to go into an exempt session, and we should absolutely avoid trying to do so because of the accountability and the transparency. I think the report that's been given to us is very clear. So I do agree with you entirely that we should have our debate. We should see if there is a need to go into exempt and what those needs would be and why we would want to. But I would be happy to go along with your suggestion that we actually debate this in public as much as possible.
But remember, if we're debating the publicly published report, we cannot include anything that we've read in the exempt report. So you're going to have to be very careful to monitor yourselves. Or we all will have to be very careful not to include anything that's in the exempt report when we talk about the public report. Have I made myself clear on that one? Because I obviously haven't before. Is that clear? So when we talk about the public report, we do not inadvertently even refer to the exempt report. Okay, so could we have someone to talk us through the public report? I'm not sure who that will be. That you've done all you want to do on that. Okay, so Miss Lay told me that her presentation was in effect the report, the presentation of the public report. Nobody raised any questions on that. Do you want at this stage to make any comments on what is in the public report and Miss Lay's presentation? Councillor Hilliard.
Thank you, Chair. I think the options appraisal at point 10 is useful to give us what we're here for today. And obviously, I think the issue of the predetermined appeal, and we thought an appeal might come anyway. I don't think there's any differential between that. The fact is that we, as a committee, had those 3 policies, and we're now being challenged to say, are they robust enough? Now, I obviously didn't think they were robust enough, and I was relying on our professional qualified officers at the time who said biodiversity connected were okay, and none of the external Natural England, RSPB specifically objected. They might have not commented, but they didn't object. And it's interesting. We were talking that Winter Watch are at Arn across the river, and they're saying they want more people to come onto their space to enjoy the wildlife. So again, for me, I'd never been to the Heath before. I was a BCP councillor, and it's opened up. Yes, it's a nice space, but how many other people don't go to this nice space? So for me, this development and the enhancements will make it more accessible. So for me, I don't think the accessibility was ever robust enough to refuse. Transport, like we said, the applicant was giving more provision, but they could easily say, all right, no, we'll bring it in line to the SBD if that's the way it is. So again, that was always a weak one. And biodiversity, again, as I said, Natural England never specifically opposed it. So again, I thought that was weak. So for me, I going back to that options appraisal at 10, maintaining the current position seems to be very unreasonable. Identifying different or reducing, again, unreasonable. So I think revising our position to put our hands up and say, yeah, we've considered the situation, but we don't think our objections were robust enough. Seems to be the way forward. Thank you.
Thank you. Any comments on that, Councillor Canavan?
Well, I just wanted, before I make any kind of comment on the report, because I've got a few things to say about it, but I just want clarification about who is entitled to speak, because I had understood from the exchange of emails that it might be possible for the ward councillor to speak.
They will be in due course.
Okay, well then I'll hang on to my 5 penny worth for the moment. Thank you.
Depends whether it's acceptable.
That's
Yeah.
And it's not now.
It depends what the ward councillors want to say, because they will have seen the exempt report as much as we have. If they want to include things that are in the exempt report, we need to come to a view on whether we want to go into exempt session or not before they speak, or else they might inadvertently say things that on reflection we didn't, stray into areas that we didn't want to cover at this point. This is the thing. Any other comments? Councillor Rice.
Well, I would have just thought that we treat them the same as committee members in that.
Sorry, I can't hear.
I would have thought we'd treat them the same as committee members in that we ask them to not speak about anything in exempt, and therefore then they can speak now. And then again, if they wish to speak about exempt stuff in exempt session.
Councillor Tarling.
Yeah, Councillor Rice has said pretty much what I was going to say. I just want to thank Councillor Liar for getting right to the nub of it. It is 10.1, 10.2, 10.3 here that we are looking at and considering. Regarding 10.1 and sort of my values, I have a view on that. If we go to 10.3, I won't be involved in the further debate. I shall then recuse myself from 10.3, and the same with 10.2. I would wish to, like Councillor Hilliard has pointed out, speak against 10.1 as being an option. I think that's a difficult position to put our officers in and this committee. If 10.2 or 10.3 is decided upon, then I will recuse myself. But I agree 100% with what Councillor Rice has just said. That I think that the ward councillors have been in this meeting. They know the same rules regarding the importance of the legal privilege. If they wish to indicate to speak, I think I would want to hear their point at this point. But they're under the same rules as the committee. Thank you.
Right, I'm minded to follow that line, that we hear the ward councillors and the councillors for neighbouring wards, but please, all of you, bear in mind not to include the exempt material at this stage. Okay, so.
Just to clarify that point, obviously for normal applications, this is nowhere near like a normal situation. Ward councillors would normally get 5 minutes. I don't know if you want to
they've been
treat them like a normal member of the planning committee, which would be unrestricted speaking, or if you want to limit them down.
They know they're limited to 5. They've already been notified of that. Okay, so can we move to the ward councillors then? So we have all three wish to speak. They're in alphabetical order on the running order, but if they wish to change the order, that's up to them. So we have Councillor Broadhead, Councillor Gellett and Councillor Rampton.
Thank you very much, Chair, and thank you, colleagues, for allowing me to speak as the ward councillor. Colleagues, I frankly can't believe that this is the third time we're here, and the question I ask is it going to be third time lucky? Because if not, I fear it's 3 strikes and we're out. The question I keep getting from residents again and again is why are we here yet again? And the answer is almost comical and sometimes makes this council look like an embarrassment. This committee in October took the completely legitimate decision that they did not agree with the officer recommendation to approve the application for a number of reasons, not least because of the widely held views that it did not pass the crucial test of policy PP21 of not having any adverse impact on the adjoining delicate heathland. Now that should have been the end of the matter. The democratically accountable decision had been taken, and if the applicant wanted to appeal, that's their right and we would fight it. But no, in what looks to many to be a case of the council being unhappy with councillors not agreeing with the officer recommendation, this committee was essentially asked to think again in a further meeting of this committee. Once again, members of this committee agreed to stick with the decision and instructed the council to strengthen the case that we would argue at appeal. But clearly that decision was flatly ignored. Instead, this council simply ignored that instruction and failed to determine the application and completely subverted this committee's decision for the second time and almost handing a free pass to the applicant. And now we're here for a third time, again asking for a further decision from the committee in what again appears to be a strong-arm tactic to get councillors to back down and change their mind. Instead of following our instructions and strengthening our case, we are presented reports in the confidential setting, which I won't talk about, which are seemingly designed to do the very opposite. What's more, to further ostracise the very public who are electors, we're being urged to reconsider much of this out of the public eye and behind closed doors. Now, colleagues, I'm not one normally who's prone to hyperbole, but I can genuinely say that this process has been the worst that I've ever seen in my whole political career and makes the council look at best shambolic and at worst subversive. Colleagues, please don't give in to these tactics. You made the decision, the right one, clearly evidenced. Stick to it, strengthen it. We may have been put into a position where it looks fruitless, but we're elected to make the right decisions, not the easy ones. Thank you.
Thank you, Councillor Broadhead. And now Councillor Rampton or Councillor Gillett? Councillor Gillett is coming.
In respect of this application, it's been put forward that some of the reasons aren't necessarily strong enough to take the case through to the inspectorate. But in PP21, right at the beginning, in General Principle 1A, it states that all development must ensure no adverse impact upon the heath. And it fleshes this out, talking about the heathland support area. This is all in the general public domain. The heathland support area was put forward as an application less than 3 years ago, and it was declined. And the reason for its decline was a negative impact upon the heath. Secondly, the light industrial estate is connected to the heathland through a triple SI. The increase in the footfall on the triple SI is a negative impact upon the heath. Since lockdown, there's been a very large increase in the number of people who take their dogs to work. Separate study by York University suggests that 1 in 4 employers now allow dogs in the workplace. Where would people on the light industrial estate walk their dogs? That will be on the heath. The RSPB stated that there would be no adverse effect if there were no dogs, but there will be more dogs coming in from the light industrial estate. The Bourne Valley Park was set up under the same principles as the heathland support area: low impact, no parking, no lighting, and fire gates, just as proposed. And these factors are made at the location where arsonists have been most successful in terms of setting fires to heath, and that has decimated the Sandler's population. So all of those are the sorts of reasons that can be added to embolden what you have here. The other thing as well, taking just under my time, I think it's possibly worth the committee listening to the resident as well. There is a resident who is quite knowledgeable on these sorts of issues, who's here today and has something prepared if you're prepared to vote to listen to that. Thank you.
Thank you. And now Councillor Rampton.
Okay, members, I'll start by saying the threat of an appeal should never be a consideration of the planning committee. And for 11 of you on the 2nd of October, it wasn't. You made the right decision and you bravely and steadfastly held your position, only to have had 3.5 months of confusion and obfuscation. You've been undermined, you've been unsupported, sworn to secrecy on some very dubious grounds, I have to say, in effect gagged, told that meetings should be exempt, members of the public banned from speaking, ward councillors, okay, thank you for allowing me to speak here, but we were told we were only allowed to speak in the exempt session. And now you're being asked what you want to do next. Presented with council advice and the summary of reports, and I won't mention the reports, but strangely not the detail of the whole reports, or more importantly, what was a brief given to those consultants who prepared the reports. How can you make an informed decision without having the full information in front of you or material only sent to you less than 24 hours before? Scant detail, and all the focus is on the cost, not the risk to Talbot Heath and its wildlife, its biodiversity. No, not interested. There will be a section 106 agreement. Okay, well, that's 33,000 from TVT, which won't even pay for a ranger for 1 year. There is no detail of the guarantee that no harm will come to the heath, just that it will be compliant with the habitat regulation. So let's just push it into an inadequate section 106. And who will oversee that 106? The same stakeholders who've been advocating for this development from the start, Natural England and BCP Planning Department. They'll be the key contributors and the only organisations who can hold the applicant to account. An applicant who, by the way, does not have the greatest track record in fulfilling their responsibilities to date. And organisations without the money or the time to do their role effectively. Policy PP21 of the Poor Local Plan states at 1, general principles, all development proposals at Talbot Village must A, contribute towards mitigation measures to ensure no adverse impact upon the European and internationally important site of Talbot Heath. Figure 30, proposals for Talbot Village on page 74, clearly shows the link of the HSA between Field 3 and Fields 4 and 5 as going through the Site of Natural Conservation Interest, SNCI, owned by TVT. Figure 30 is not a diagram, and I have read this before, as said by the case officer. The positions of TV1, 2 and 3 are shown in the Ordnance Survey map. The application deliberately takes a chunk, part of footpath 33, and makes it part of the HSA as a link between the fields. This cannot be anything other than a direct adverse impact upon the European and internationally important site of Talbot Heath, and therefore it's contrary to policy PP21 1A. Can you please add this reason with policy number PP21 1A to your refusal? And please remember also, I've said this before as well, the HSA is only required for the lifetime of the innovation quarter. What happens then? Is that land too up for grabs? Committee, please stand firm. Please do not allow your democratic decision to be further undermined or changed. Don't allow yourself to be feared, that's a Scottish word, of implied threats. I started off by saying the threat of an appeal should never be part of decision making. If it becomes so, then the committee is toothless and will be held to ransom by those with seemingly bottomless pockets. And then where will we be? Remember, thousands of BCP residents are right behind you, willing you on, hoping and trusting that you will do the right thing again. Thank you.
Now we have a written statement to be read out by Councillor Gillett from the 2 ward councillors of the neighbouring ward, the adjacent ward, Wallace Down and Winton West.
Could I suggest, when we've heard from the adjoining ward councillors, that the member of the public be?
We'll talk about that after.
Thank you.
So this is a statement to the planning committee from councillors Olivia Brown and Rich Herrett. Dear committee, Having seen the expert advice, it is unfortunate that we are in this situation, but we must also ensure that the committee is heard and the representations are made and relevant rights is respected. However, we would implore you to ensure that the traffic provision is at least strengthened, parking above and beyond the necessity, and the absence of actual hard funding to improve the walking and cycling network beyond the boundary roundabout north or west. The travel plan lent heavily on these and would therefore mitigate the traffic impact. But in the absence of what is there currently, nor funding to continue in sight, that would mean that the parking provision is not currently resolved. It is worth noting that the parking provision is also easy to remove, and the applicant does not appear to have volunteered to do this, despite the report identifying that it was over-provided. The mitigation and impact of cars on the site and the residents living on the roads and around the site is therefore incomplete. Reasons not included at the initial stage but impactful as a result of this over-provision of car parking was due to the induced demand generated by over-provision of cars. There will be more than necessary increase in congestion, an increase in air pollution over and above that which would be there. The absolute number on all roads and around the site have been maintained. There's an increased danger to walkers and wheelers and lack of infrastructure that the travel plan relied upon not being funded. Finally, this induced demand will be felt further afield as the traffic makes its way across the conurbation. Thank you.
And now our last speaker, last councillor speaker, is Councillor Tony Trent from the another adjacent ward, Alderney and Bull Valley.
Thank you. I'm not going to repeat my previous comments. I think that's all a case of public record. And there are two bits of this that I could only repeat if it in the closed session, because it refers directly to what was the advice there. But at the planning committee meeting on the 2nd of October 2023, where I spoke as an adjacent ward councillor on behalf of several residents who had expressed objections, I offered 3 reasons which I thought would be reasonable reasons for refusal. I must admit to having been surprised that others had said how much they opposed the proposed development, but didn't offer specific planning reasons for refusal. The 3 reasons I offered at the meeting were all lifted from the Poole local plan passed in 2018. 2 of these reasons were proposed and seconded by members of the planning committee as part of the refusal. Another one was not accepted. I've called it PP32, but it's obviously not, because the wording is different to the PP32. So I shall have to ask someone if they can sort of look it up, but I'll quote it in a minute. But one reason was particularly relevant, as it suggested that the Poole local plan should be reviewed by 2023. The fact that there is a proposed reduction in one element of the application, the amount of planned employment land, is particularly relevant, as it would allow for a better buffer zone and might even make it possible to create the urban farm which some of us were championing more than 10 years ago in a joint Bournemouth-Poole local food working group. There is evidence that the area of Talbot Heath and the adjacent residents have benefited from the presence of the farm that still operates. It certainly protects the rear of houses in Winston Avenue. Maybe the fact that there is now a new local plan being submitted with a direct change in detail relating to the application in question from the need to be reviewed Poole local plan is now a material consideration in itself. Another material consideration has to be the huge growth in working from home these last 4 years, and this might very well be freeing up more premises for light industrial from previous office designation, backing up the proposed reduction of employment land in Talbot Village. Another reason to support the re-examine of the previous plan and the update, further supporting the decision of October the 2nd. I believe the committee should respect the original determination 10.1, but beef it up in 10.2. The next paragraph, I think, comes under the exempting, but I'll just quote from the planning reason, which I think is relevant. As I say, I had it down as PP32, but that's probably a problem from cut and pasting. The council will review the pool local plan by 2023. The review will need to assess whether the growth plans for 2023-2033 can be successfully mitigated. A study into the success of mitigation measures since 2007 will be a fundamental part of the evidence base. If there is no certainty that development will not have an adverse effect on protected wildlife, the council may not be able to grant planning permission for certain types of harmful development. And it says such as housing, but I think it's the first line that is important in this, that the recommendation in 2018 was that the plan would be reviewed by 2023. There is a early submission of the successor local plan, which does actually change materially what is permitted. So I believe that is a very strong reason why we should not only stick to the original recommendation, but look at other reasons that can be added to it as suggested in 10.2. Hopefully that makes sense.
Thank you, Councillor Trent. Councillor Williams.
Yes,
I wanted to speak.
Yes, I wanted to propose that we hear from the member of the public who's a former borough solicitor to Bournemouth Council, so he is quite knowledgeable, and a former councillor.
Councillor Hilliard.
Thank you, Chair. I think it's dangerous that obviously other people from both sides probably wanted to speak at this committee and were told not, so they haven't actually turned up here. So I think it would be dangerous to allow someone where we probably told them otherwise, but maybe the solicitor could give an opinion. Thank you.
And also presumably he won't have seen the full paperwork. He shouldn't have seen the full paperwork.
I mean, I think the point was well made. Clearly, some people might feel aggrieved if you suddenly allow people to start speaking who haven't been allowed to speak. But I can't say much more than that. I mean, what it obviously does is create an issue which people might take up subsequently, possibly through the courts. Who knows?
Any further thoughts? I don't think that it shouldn't make a difference. Yeah.
Can we take a vote on it?
Councillor Hitchcock, I don't think you've got your microphone on, so. Sorry? I did, but the public won't. Anyone watching won't. Yes, please.
Okay, I just think if we've got an expert here that wants to give some advice to us, we made the decision that we wanted it to be refused originally. If he's on our side to help the case moving forwards, then I think we should hear what he has to say.
Councillor Tarley.
Yeah, I was going along with Councillor Hitchcock until he said on their side, and that's actually the point that Mr. Firth has just, or something, I think it's Councillor Hilliard made, that it's important to hear all the evidence and the balance, and whether you bring it into the balance of consideration. At the moment, we're discussing about go back to Councillor Hilliard's first point, is 10.1, 10.2, 10.3. And not really the material facts, which I won't be having. So yeah, won't be. But regarding whether they're for or against, really should have no bearing on it, because we're hearing about whether we should be reconsidering this or not. And some of the arguments that have been made from the other councillors, some are pertinent to the decision in the options appraisal. Some are actually part of the material consideration of the application. I don't know what a member of public could add to the consideration of paragraph 10 that this committee is going to make, which is what we've got to do first before we go on to doing either 10.2 or 10.3, which is really substantial elements of that application. So it's unfortunately, we're just making this the legal minefield. We're planting more mines in this minefield at the moment. I do feel sorry for our officers that are going to have to defuse this situation at some point and clear some of these mines that we're laying all the time. I don't know the answer to Councillor Hitchcock, sorry, through you, Chair, about that. But I would say that, because to say that you want to hear them because they support your view is exactly the reason why we shouldn't hear them. To hear them because they might add some light or shed some light to the debate that we're having at the moment on paragraph 10, I think would be relevant. So unfortunately, Councillor Hitchcock, if you withdrew that comment about why, I would support him on that.
Thank you. Councillor Dove.
Thank you, and thank you, Councillor Tarling. So I was inclined to want to hear, but trying to understand why that would be, other than just perhaps curiosity and what value it would add to what we're listening to today. And you are quite right, we don't know what they're going to say in respect of paragraph 10, and then your very last sentence has definitely reinforced the fact that actually we should be listening to them, and if it is pertinent and relevant, then we'll absolutely take that on board. And if it's not, because as you said, don't know what they're going to say, we don't know what value they're going to add, then I think we're all experienced members, we're all trained members of the planning committee, and therefore we will disregard those comments. So I'm inclined to support Councillor Williams' proposal.
Mr. Mills?
I'm not sure it's going to help, but I'm going to try and offer a few further observations. So there's two ways this committee is now proceeding. It's either proceeding on the basis of the protocols for public speaking, or it's proceeding on the basis of the general provisions of the Constitution. If it's proceeding on the basis of the protocols in the Constitution relating to public speaking, then I think there's 2 points that are relevant. First of all, the protocol makes clear that actually it's at your discretion, Chairman. Now, that doesn't mean you can't be informed by the members, but the protocol says it's at your discretion. The other thing, and I think this may be pertinent equally, is if you're going on the basis of the protocol, then it actually makes clear that obviously if you're hearing the people speaking, they should only be referring to planning related issues. And I'm not at this moment convinced that's what you're going to hear about, but I don't know because I haven't heard it. But obviously any speaking should be focused on planning related issues. And that wouldn't, of course, be related to matters of protocol or procedure. If you're not working on the assumption that the protocol applies, then I think you're falling back on the provisions of the Constitution, and bear with me while I try and find that. But again, I think the long and short of it is going to be, and I apologize, I'm going to have to find it now, but from what I recollect anyway, and I will check the point, that's at the discretion of the chair as to who you're allowed to speak. So however you work the process, it comes back, Chairman, to, I think probably it is at your discretion, but that's not to say you can't be informed by the thoughts of your colleagues. I don't know if that helps a lot or not.
Sorry. I very much take the Vice Chair's considered opinion that we have not allowed any members of the public to speak at this meeting. They have not been offered to speak. And any who might have approached us, I think, would at that stage have been turned down. So I don't feel it is right to give what could be called preferential treatment to someone who is has people lobbying on his behalf to speak, and we have no idea what obviously we don't know what he's going to say, but if he is clearly only sticking to the 3 options in point 10, that is what we are here to discuss. Otherwise, to stray beyond that in any shape or form is not what we're talking about at the moment. I don't know whether anyone can throw any light on whether we can guarantee that this speaker only wants to speak on point 10, the 3 options. I suspect that's not possible. Councillor Clements.
Thank you, Chair. Personally, I feel regardless of what the speaker may or may not say. If there has been a decision previously made that everybody else other than the committee is excluded from speaking, then we should stick to that decision.
Yeah, that's my feeling. So I'm ruling that he should not be permitted to speak at this stage, or at any stage. So we're back to discussing point 10, the three options, and within that, at some stage, we need to look at whether it's felt we need to go into exempt session or not. But are there any more speakers on point 10? Councillor Canavan.
Yes, thank you, Chair. I find myself in a situation where I agree with much of what Councillor Broadhead said earlier on, but I do think it is important to recognise the very professional report that came before us on the 2nd of October. Even if we disagreed with some of it, it was very professionally put together, and I'm very grateful for it, and indeed for the very worthwhile site visit that we had. That was incredibly informative. So I am very grateful for all of that. I think it's important that we recognise that. And obviously, when it came before us on the 2nd of October, we received all of that and we were grateful for all of that. But then it's our job to make a decision, isn't it? It's our job as a committee to apply our judgment and our views against that professional advice. That's what we're here for. And I thought that's what we did, to be honest. And I think this process has gone downhill ever since 2nd of October. And that we've got ourselves into a considerable mess. I agree with Councillor Trent. I don't necessarily think 10.1 or 10.2 are necessarily mutually exclusive. My interpretation of the word different can also mean additional. And I had the expectation, naively, possibly, that when we left that meeting of the 2nd of October, that officers and everybody really would be allowed to try and get the strongest possible wording for the refusal in order that we had our strongest possible case. And I may be misquoting one of the authors by saying it was better to have one strong point of objection than several quite probably not so strong objections. I'm not sure I was necessarily convinced by that argument, but I do believe that argument was posted. That's why I don't think 10.2, you know, if it's just about refining down the original objections, it is worthwhile. You know, my view remains that we need to find, whether that includes finding additional points, the strongest possible wording in support of 10.1 that we can to substantiate our position. And I'm not going to get into the advice or the exempt session. I've got plenty to say about that, but the point I'm coming back to is that on the basis of the options appraisal, despite what the Vice Chair said earlier on, it's my view that 10.1 remains should remain the focus. I am absolutely convinced that that's the right position. It may not be the ultimate, you know, outcome of all of this, but we can't judge it on what we anticipate the ultimate outcome of this will be. We have to judge it on the basis of what is best for our residents, and be prepared, in my view, to defend that position, even if ultimately, you know, somebody else down the track makes a different decision. I think it's incumbent on us as democratically elected representatives to do that. And I know, you know, the legal ramifications of that. I'm aware of that, but I strongly believe that our decision that we made in October was right, because it reflected the overriding concerns that we heard at that meeting from, you know, the impact on the heath and the traffic and all of that, and really we just I felt we needed to put ourselves in the strongest possible position to respond to the application, to record that decision, and to find that we were in a situation where nothing happened effectively after the 2nd of October. We're now in a situation where it's been the appeal on the basis of non-determination. I mean, the word frustrating doesn't really cut it, in my view. So that's just my view, Chair. Thank you very much.
Thank you. I don't want us to enter too much or at all into criticising behaviour or lack of behaviour. There may possibly be a point for that in the future, but this meeting is not that point. Councillor Tarling.
Yeah, thank you very much. This is I'll respond to some of the other councillors speaking. Firstly, Councillor Broadhead mentioned that this is the 3rd time that we've been asked to consider this. Madam Chair, I don't think that's actually true. The 2nd time we were told that we're going to be presented with a detailed legal report, and we didn't actually debate what we were going to do on the 2nd. So this is actually the 2nd time of discussion. The 2nd meeting we had, it wasn't a point of discussion. We were told we were getting a report from legal counsel, which we didn't get, so we deferred that to what is effectively this meeting. I do pick up what Councillor Ampton says, that we basically got this with less than 24 hours to read it, but I hope every councillor here has read the exempt part of that and has taken that on board and what they've said today. Councillor Ampton mentioned here about an additional reason for refusal. That would lead you to decide upon 10.2 as being the way forward to sort of strengthen or review it. And I didn't make that. Unfortunately, I heard it round the wrong way, so I didn't pick up what that was. If anybody else picked up what that additional reason or strengthening thing would be for that. Councillor Trent then went on to the future local plan, which it is highly unfortunate that we're not considering that, and this is a virtue of taking time over the local plan means that we haven't been able to review the policies which cover the employment area, and potentially it's not been adopted yet and not gone through a planning inspector, but obviously reduced employment area. So it isn't a material consideration necessarily for this, but if you were to put it into the fine balance of making decision, the committee members that were involved in, the substitute members involved in the original decision-making process. I agree 100% with Councillor Broadhead and Councillor Rampton with the democratic rights. I couldn't agree more on that, but we also have to acknowledge that we put our officers in a position they have to respond to it, and I extend my sympathies to our officers that have had to deal with this. And this unfortunate position, planning law doesn't allow us to do that. Going to the pins is not the be all and end all of it, and whatever comes out of this will be, the appeal is now lodged, it will go ahead, and what we're considering potentially in closed session is for closed session. But again, the democratic rights of this committee, I don't agree. I didn't agree with the committee. I wasn't part of it because I couldn't attend the last hour of the or 2 hours of the site visit. I would have voted the other way, but I do respect that this committee exercised its democratic rights and processes, and I agree 100% with Councillor Canavan that although I don't agree with him on it, I defend to the hilt his right to be for his view on that, and it requires the wisdom of Solomon. So with that in mind, I think we are going to be at a point fairly soon where we do need to discuss the closed session and the points we need to discuss related to the next steps of the process in appeal. We've had a lot of talk about the actual material facts of planning, and until we've agreed whether we're going to reconsider that or not, it's sort of superfluous. So I've really come back to what Councillor Hilliard said. We're looking at 10.1, 10.2 and 10.3. What are we going to do about this? And I've heard the arguments, but I haven't heard anybody actually propose a way forward, or whether we need to go into exempt session to discuss the contents of that report to inform us further on that. Thank you.
Thank you. Councillor Salmon.
Hi, yes. Just before we go on to talking about going back into talking about exempt sessions, things like that. We heard from 3 ward councillors and all of, sorry, we heard from 4, but 3 of them gave specific strengthening reasons in terms of our grant, the current proposed grounds for refusal. And I would like to talk about adding those in to our existing grounds for refusal, because that's one of the options that's in front of us, 10.2. And we've been given very eloquently well put together arguments which refer to the pool local plan as to strengthening some of those grounds for refusal. So can we talk a bit about adding those in, please?
We can. Are members ready to enter into the detail of that discussion? And are we happy that it is in public session, or do we need to go into exempt? Because we may want to be talking about details that are included in the exempt report when we're starting to look at details of 10.1, 10.2 and 10.3. Councillor Dove.
Thank you. I'm happy to remain in public. We understand the parameters in which we are operating. We've all read the exempt information. I'm perfectly happy to contribute to the discussion without referring to that. And I'm happy to proceed as Councillor Salmon is suggesting. And I do believe that should be out in the public so that we have some degree of transparency and accountability for everybody involved in this process, not just the residents, but also the applicant, to understand how we've reached any decision that we have today.
I've got a problem because there are things I would want to say which will involve referring to the exempt report. So it won't be a free discussion for me if I can't include things that are in the exempt report. So Councillor Canavan first, and then Councillor Tarling.
Chair, it was a question, really. If, for the sake of argument, we replaced the word certain in 10.1 with additional, would that allow us to incorporate the points that Councillor Salmon's just referred to? If that is the case, but by that slight change of wording, if that would enable us to do that, then I'm prepared to move it now.
Can you repeat the word you want to replace certain?
Well, I was asking whether if we replaced the word certain with the word additional, whether that would allow us to incorporate the additional points that have been raised this morning in terms of our position. If that simple change would allow us to do that, then I'm happy to move it. If we think we need to do different words, then let's identify what those other words might be. But I think it's important that we try, if we can, to incorporate those additional points that have been raised this morning into our position in terms of the response to the appeal. Thank you.
Councillor Tarling.
Yeah, Madam Chair, you've indicated that you wish to discuss stuff that's in a restricted part of the documents, and although I understand certainly what Councillor Dove says, and I'm supportive of it being public, I'm actually making a proposal. We've moved into closed session so that we can discuss the contents of that report to satisfaction, but then we carry on the debate on the actual paragraph 10. We come out of closed session for that. So I am making a proposal to go into closed session for a short duration so that, Madam Chair, you and any other councillors that have issues with the confidential report or restricted report can discuss that. Thank you.
So, Councillor Canavan. Oh, sorry, I can't see your hand.
Thank you, Chair. Just wanted to say I'll second that.
Okay, so we've got a proposal seconded, and now Councillor Canavan.
Well, I'm sorry to be difficult, but I don't believe we should be going into exempt session at all. I understand the whole concept of legal privilege. It's spent my working life having to deal with it, but this is so important, I believe, to have this out in the open for public consumption, I would be opposed to the whole idea of going into exempt session. I believe it is not necessary. So if we are going to have a vote on it, then I will be voting against that. Thank you.
Councillor Dove.
Thank you, and I agree. And also because we have exempt information doesn't mean that we must go into exempt. It is up to the committee to decide whether we should. And the reason that I'm suggesting, and I would agree with everything that Councillor Canavan has said, is because actually the information that you get from the government website about and on the LGA sites, etc., are very clear that actually as much information should be shared in public, and that the public interest test has to be met. And I don't think in this case the legal information outweighs the public interest. And there are certain things here when you look at what that public interest test should be. It's about the public interest in disclosure is particularly strong, where the information in question assists public understanding of an issue that is generated public and parliamentary debate. That it affects a wide range of individuals and companies. The public interest, it attracts also local interest groups, and having sufficient information to represent effectively local interests on an issue, to understand facts and analysis behind major policy decisions, knowing reasons for decisions, and accountability, openness, public interest in public bodies, and also damage to the environment is another reason as to why you don't have to go into exempt or shouldn't go into exempt. And furthermore, the government will go on to say that where the public interest factors in deciding whether you should go into exempt, it should further the understanding and participation of the public debate of issues of the day. It promotes accountability and transparency by public authorities for decisions taken by them. It promotes accountability and transparency in the spending of public money. And more importantly, it allows individuals to understand decisions made by public authorities affecting their lives, and in some cases assist individuals in challenging those decisions. And it brings to light information affecting public safety. So on that basis, I am not going to support the proposal that we go into exempt. I don't believe there's anything in there that really should be out of the public domain. I think the public interest test hasn't been met.
Thank you. The problem in my mind is the status of the report, because as I say, there are things in that report that I would want to refer to, but if we're not allowed to refer to it, it actually doesn't aid our discussion, it hinders it.
You can refer to it. It's up to us to decide.
I'm asking for legal advice on this.
Chair, if I may, just address the public interest issue prior to the committee entering into a vote. As the monitoring officer, I am aware of the contents of the report, and that I note an appeal has been lodged challenging the decision of the committee in respect of this matter. In short, this is the council now being in litigation. This is not policy making. As per the recommendation in this report, the committee must now determine how it wishes to proceed in respect of the current live appeal. However, officers must also ensure that the best interests of the council are maintained. In addition to the recommendations of the committee, which I acknowledge and have been fully debated thus far this morning, and I have observed, as I was not employed by the council during October, I have observed the meeting on 2nd of October 2023. As the monitoring officer, I must take into account the following. Firstly, the views expressed by the planning officers, noting that they recommended approval, and this is in addition to the views expressed by the planning committee. The financial implications as detailed in the report, the legal implications as detailed in the public report, and the more detailed legal advice contained within the exempt supplemental agenda. And I also note the options available to the committee this morning. Upon consideration of all of this information, I am satisfied that the withholding of the material contained within the exempt supplement agenda does outweigh the public interest test in disclosing the same. I would reiterate that my primary reason for this is that the council is currently in effect in litigation, and that does have the ability to affect the council's reputation and also affect the council both from a financial and a legal position. I hope that assists, Chair.
Thank you. So we'll move to a vote. We've had a motion proposed and seconded. A lot of people, although not all of us, have spoken on the subject. So we're moving into a vote on the motion, which I've got to find the wording of to read it out. I don't think it's, yes, it is. So the resolution to exclude the public and press, that which is if in effect going into exempt session, that under section 100 brackets A brackets 4 of the Local Government Act 1972, the public be excluded from the meeting for the following item of business on the grounds that it involves the likely disclosure of exempt information as defined in paragraph 5 in part 1 of schedule 12A of the Act, and that the public interest in withholding the information outweighs such interest in disclosing the information. That's the end of the resolution. And there's an explanation here that paragraph 5 says information in respect of which a claim to legal professional privilege could be maintained in legal proceedings. So it's the legal aspect that is paramount here. So we have a motion, as I say, proposed and seconded, to go into to exclude the press and public. So those in favour, please vote now.
1, 2, 3, 4.
Are those against?
1, 2, 3, 4, 5, 6, 7.
And any abstentions?
1.
Chair, I'd like my vote recorded, please.
Thank you. So that means we will not be going into exempt session, which means you will not be able to refer to any particular aspects of the exempt report.
Sorry, Chair, it doesn't mean that at all. It does not mean that at all.
Can I have a clarification? Have I misinterpreted?
No.
Chair, if I may, the council has ruled that it will not go, the committee has ruled it will not go into exempt session. However, the information in the supplemental agenda does remain exempt. It does remain the subject of legal privilege, and it does not mean, because of the council's vote, the committee's vote, that that information is now in the public domain. That information remains exempt and remains in private, so it cannot be debated in the public element and the continuing public element of this meeting.
So bear in mind, you are very limited on what you can say in relation to this now. Councillor Tarling.
Sorry, I did just propose it because I felt that, Madam Chair, you wanted clarity, some legal advice or advice that's contained in the report. However, we've decided at this point that as a committee that we don't want to go to exempt session, that we're to carry on debating, not directly referring to the restricted information, but our democratic officer has just pointed out this is still restricted material. It doesn't get de-restricted unless it's it was voted on. Well, actually, I don't know the process of de-restricting information, but having worked in the security industry,
I suspect it's not in our gift.
I've never been in a situation where I've seen information easily de-restricted. So it is still restricted. We cannot refer to it. So if minded so, sorry, Madam Chair, I'm happy to continue debating without referring to restricted material. I noticed, Madam Chair, I proposed it because you had some questions about it. And I obviously, if you feel so minded that you absolutely can't debate any further without reference to that material, there's another proposal brought forward to go into exempt session if it needs to be discussed publicly. Thank you.
It wasn't so much that I feel like I can't debate further. It's that there are things I would probably want to say that specifically refer to items in that report, which I now won't be able to do. Councillor Rice, and then I think Councillor Salmon.
Thank you. I submitted some information after the committee meeting back in November with concerns that I specifically wanted to make sure that legal counsel were looking at. Can I just get clarification? So did we get any legal counsel to look at those points that I raised? Although Robert's probably directed at you, Robert. Would you like me to repeat it again? So I submitted some additional information by email following the committee meeting in October. I submitted it in November, and the point of that was to ensure that we were clarifying all of the legal points that I wanted to ensure were checked by legal counsel. Can you clarify whether legal counsel have actually looked at that then, or have we not had legal counsel advice?
I think my answer has to be, bearing in mind we're in public session, that regard has been had generally to any comments that were submitted by members. So that's my answer, I'm afraid. It's regard has been had to anything that members have provided up to this point.
Councillor Salmon?
Yeah, so where this kind of started from was me saying, can we try and strengthen some of our existing grounds for refusal? And I appreciate, Chair, that you felt you couldn't talk about it quite as fully as you wanted to without referring to the exempt report. I apologise. I just think the things that have been said so far have been in public session. The proposed grounds for refusal are in the public domain. So I feel like there is more we can do in public session, which is why I voted against. So could we maybe bottom out some of those, strengthening some of those reasons at this point and talk through, because I think we've got proposals around adding things from PP32, adding things from PP21 that weren't referenced in our grounds for refusal in October. They're very specific, they're very clear suggestions that we add to our grounds, our existing grounds for refusal. Just feels like that would be the next step to me.
That sounds.
Sorry, Chair. I actually apologise. I was speaking again to my colleague. I missed it. But if what was said, and I think it probably was actually, it seems a sensible position now that we take members back to look at the 3 reasons they came up with, focus on those and see if members want to change them, expand on them, or otherwise. That seems to be a sensible way forward. I think that's probably the tail end of what was being suggested. And so if that's it, Chair, that seems rational. I think that's something that my 2 planning colleagues to my left can now direct members to.
Okay, and specifically to look at some of the things that have been suggested by the ward councillors who spoke earlier in terms of adding to our existing grounds for refusal, because I think there are extra parts of specific policies in the pool local plan that were suggested for reference and expanding on the existing grounds.
So, have you got some specific items in mind?
Yes. Councillor Trent referred to another part of PP32, which isn't referred to in our existing grounds for refusal, around the pool local plan being reviewed by 2023, and the draft BCP local plan that could be considered as that review, and the change in the land allocation. That's an interesting one to maybe have some more officer direction on, because I know there's a lot of back and forth about how.
Can I come in on that? It's an issue I've already raised with officers. I've been advised that the emerging local plan, well, it's not at the stage of actually being emerging.
No, I understand.
We're still further back, and that is not relevant to be considered.
Okay. Councillor Trent's point was about existing policy PP32 and a statement about the review of the plan being carried out by 2023. So that was the additional element to that I think is not been. I've not heard anything about that before.
Mr. Perth?
Mr. Chairman, I'm happy to kick off, and I'll defer then to my planning colleagues as necessary. So on that specific point, I think my understanding of PP32 is essentially its housing origins from the Conservation Habitats Regulations 2017 and the general overarching provision there under Regulation 63 of protecting European sites and not having an adverse effect on European sites. That's the origins of it. It seems to me, from the way it's worded. Yes, it might be the council will review the local plan in 2023, but the question is, ultimately, is there perceived to be an adverse effect on the protected European sites as a result of this proposal? And my understanding, and I'll turn to my colleagues to clarify the view, although to my left and to my right, I apologise. I'll turn to my planning colleagues to clarify the view, is the view of the ecologists is this will not have an adverse effect on a protected European site. The mitigation in place will address any adverse effects that would occur. So that's my understanding, but I can now pass to my planning colleagues to clarify the position.
Mind if I come in? Yeah,
certainly do.
Okay, thank you. Yeah, exactly what Mr. Firth just said, but also we need to remember the HSE land management plan as well, which is there in that is specifically there to pick up any kind of heading towards or trend towards adverse impacts before they occur, so that they can then intervene. So that's why the statutory consultees have signed up to that as well as being happy with the proposal. So yeah, it's also remembering the statutory consultees are content with the proposal in terms that it's not in accordance with policy PP 32. Yeah.
Yeah, if I can assess, I don't know if it helps Councillor Salmon, but I also understand we have the Council's internal ecology officer online. So if you would like to hear from them, I think they are available if that would assist at all, but she may not.
Yes, happy to do that. I'm sure.
Mr. Chair. Jess.
Yes.
Mr.
Martin, welcome.
Hello, Chairman. Yes, as the case officer has said, Natural England and the conservation organisations have been consulted on this, are content. Doesn't mean they necessarily support the application, but are content that there will be no likely significant adverse impact on the protected site, based on the proposed future management, which we have to accept, will be implemented. And also there is provision within that for the council to be involved to make sure that it is directed in the right way and to be effective.
Thank you very much. That confirms what was in the original report, that there were no objections from any of the environmental ecology organisations at all.
Correct.
Thank you. Councillor Salmon.
Thank you. So yeah, the officers have brought me on to the next point, which was raised by the ward councillors, which is what I'm trying to kind of go back and make sure we discuss, which was Councillor Gillett, who said about the proposals for the Heathland support area, and he put forward the evidence of a very similar scheme that we have some local concrete evidence of how well or otherwise such an initiative works, and so I wonder if that's something that can be added as part of our grounds. It seems to me that it's very pertinent information that we need to be taking into account around the Bourne Valley Park and the fire risk because of the way that the place has been designed and the impact of that on habitats, which has been absolutely devastating.
Thank you. The trouble with that in my mind is that it is quite clearly in the local plan, which at the time went through all the processes, all the inspectorate, listened to all the objections, and it's in the local plan. And I must remind the committee, because I think we're losing sight of this, that one of the first things we have to look at on any application is, does it conform to local plan and national plans? In the local plan, the Heathland extension, whatever it's called, is quite clearly there. One of the ward councillors referred to figure 30 in the local plan document, which clearly delineates where it is, where it should be. To say now that we can't support a TV3 as a Heathland, I can't remember what the word is. What does the A stand for? Sorry? Or it's an S, support area. Flies absolutely in the face of the local plan, which is putting us in a very bad position when it comes to the appeal. I'm looking at it. I know I take the point that appeal in many ways shouldn't colour our decision, but when we shouldn't it's foolish to put ourselves in a position of putting as a reason for refusal something that's going to be absolutely run over by the inspector, and I'm sure that one would be. Yeah.
Thank you. I think I need to rebase us, I'm afraid. So taking you back to the sequence events, there's been some slight misinformation, I think, shared at the session today. So the sequence events that and again, I wasn't working for BCP at that point. I purely looked at the time frames. So they say there was the resolution. Because it was a policy compliant proposal in line with an up-to-date development plan, legal advice was sought. Legal advice was sought on the strength and the defendability of those reasons. Advice was given that there were serious concerns. It came back to planning committee and it was agreed that external expert advice be sought very much for the reasons that members have highlighted today. Members passionately believe that this isn't the right site, but not really with reference to what the local plan sets out. There is a feeling that that this isn't the right location, but that isn't because that isn't what the development plan says. And decisions have to be made in line with the development plan unless material considerations say otherwise. And all those material factors were there when the policy was set. So, as I say, we sought external advice. That's obviously how that's then been pulled together is in the exempt item, but I think I can make some comments about that in a minute. Then we are back here. Officers fully respect the role and responsibility of elected members in the decision-making process. But there may be occasions on which prospects of success are so bleak, the better course would be to not defend an appeal. The cost of defending appeal can be substantial and members and officers need to pay heed to the risk of an adverse cost award. You were told by a member earlier that that isn't a material factor. I'm sorry, it is. It is a material factor in decision making. So you do need to take that into account. The planning inspectorate has provided documents, and so has the government, on how appeals are considered. And I'm just going to refer you to the component that talks about cost awards. Cost awards are there because all parties are expected to behave reasonably to support an efficient and timely process. Where a party has behaved unreasonably, and this has directly caused another party to incur unnecessary or wasted expense in the appeal process, they may be subject to an award of costs. So the aim of the costs award is to encourage all those involved in the appeal process to behave in a reasonable way and follow good practice. It's to encourage local planning authorities to properly exercise their development management responsibilities, to rely only on reasons for refusal, which stand up to scrutiny on the planning merits of the case and not add to the development costs through unavoidable delay. And it's to discourage unnecessary appeals by encouraging all parties to consider applications as they come forward. So that's where we are. Officers consider that the local planning authority cannot defend this appeal against non-determination. This was raised when we had that first session. We went back and we have tried, and we've gone to council twice. We've gone to experts to try and get that evidence that you require. It is compliant with the development plan. It cannot be defended as far as we are concerned. And we have shared that in the exempt session. But we would, of course, attend the inquiry to assist in relation to planning obligations, conditions and other matters. But we don't consider that the council should defend the appeal and meet all the costs. If the council acts unreasonably, then it's entirely reasonable that that is done. And that includes trying to make a spurious case that isn't supported by professional evidence to support its reasons for refusal. And there is many examples, including, I've just got an example, in fact, I've got a couple of examples in front of me, but there's a particular example in Wildham when a planning application for 700 homes were refused. They persisted in doing a case and then withdrew it later on in the process because obviously, say at the statement of case stage and the statement of common ground stage, it was clear that the council could not substantiate a case that was compliant with policy. They still got a significant cost award of £440,000. we are travelling down a route of being in that position because members seem to want to substantiate a reason for refusal which is not supported by development policy. So I need to make that really clear to you, the risk of going down this when it is compliant with the plan. And the issues that you've raised were looked at multiple times, including external advice, and the advice still from your officers is that it's an indefensible appeal. Thank you.
Thank you, Ms. Day, for that clarification. I have to say that that is entirely my view and has been all along. It's not a question of whether we like it, whether we think it's right to develop this ground. It went through all the processes prior to 2018. It went to inspection. No doubt people who objected to this development made their case at the when it came up for inspection. I didn't attend any of the sessions, so I don't know, but I'm sure they must have. I was even one who voted against this local plan when it came to council, as one or two members maybe here did, but a majority, including some people who are now objecting to this application, voted for it. I respect that that was the decision of the council following the recommendation of the investigation by the planning inspectorate and all the relevant authorities. So I am doing my best to uphold it. Those who voted for it basically have put us in this position, being blunt. So this is the local plan. Anything that's compliant with this, we really have no option but to agree to it. There might be details, for instance, possibly the car parking because it's over provision, but whether that in itself taken to appeal would get this application dismissed. I suspect it wouldn't, but I don't know. I'm not an expert, but just the over provision of car parking, which would be negotiable, I'm sure that would not be a deal breaker. That it's not, that on its own is not worth going to appeal about. Sorry, I've got that off my chest. I've been waiting for weeks to say that. So, Councillor Rice.
So I appreciate the summary. That was very helpful. My concerns, which I did raise in my document, are that some of the information provided by the applicant my concerns are that the information provided was not accurate. So, for example, well, it was all in there was multiple aspects, but basically the environmental organisations such as the RSPB and Natural England, I'm concerned that they were basing their non-objection, because they did originally object, and then they received further information, and I'm concerned that that further information was inaccurate based on the HSA that was provided by the applicants. So I raised concerns about the fact, for example, they speak about a flat, that the access to the heathland area would be down a steep path. So reading that HSA document, such as a representative from Natural England may think, okay, well, this is reasonable, like it's not actually very easily accessible. However, it's inaccurate. There will be a smooth, much more easily accessible path once this development has occurred. So therefore, and there was multiple aspects in there about that. They referenced a report that supposedly justified that workers are not likely to go onto the heathland, but that survey report was actually done by the same company as the applicants, and it was also pre-pandemic. And it also, the same company, if you look at their website, actually then went on to say, lunch breaks are so short, that's not good for productivity, it's not good for a workforce. So actually, how can we extend and make sure everybody does take their lunch breaks? So the information was very conflicting that was provided in the HSA, and that is what the environmental agencies were basing their Previously, they had objected. They then received an adjusted HSA, which I believe has misleading information in it, and therefore I remain concerned.
Thank you. Mr. Perth?
The chairman has said, I mean, obviously to have regard to all information submitted, but I think we can probably give a bit more clarification on that.
Yeah, I think it would be helpful. So if we start with, I think Councillor Rampton raised this as well, the rights of way issues. There was a concern that perhaps statutory consultees and everyone weren't looking at the right information. So I mean, statutory consultees were aware, and I'm actually busy talking to them to try and get them to put that in writing, and they are. We've discussed this with them, but when we've thought about this and spoke to ecologists about this, it actually it's not that pertinent. We actually need the HSA to be accessible. So, and this is a HSA. This is not a SANG. It's not a destination. It's not a country park. It's a very different beast. It is there to mitigate any impacts from the proposed development, nothing else. So it's not for existing residents. I did read your, the references that you put in about workers. That kind of thing is taken into account, that we don't know what their patterns of. You don't know what, we can't guarantee every person is going to go onto the heath or not go onto the heath, which is why the management plan is in place to assess what's going on and what people's habits are, and then to amend practices as needed for the lifetime of the development. So they are aware of it. It needs to be accessible. We hope that it will draw people from the proposed development, and that they will access that. To access it, absolutely, sometimes you have to go through the rights of way that absolutely do intersect the SSSI, the Ramsar. Again, statutory consultees are aware of this, and they're content with the quantity of the HSA and its design. And I think sorry, I've made notes here. I'm just trying to read. What could also happen, and what it could actually help with existing football as well, in terms of, we have we've all been on the heath. You've got the designated kind of well-worn pathways there. So for one, habitats, they will tend to avoid those areas, full stop, because they know that obviously that could impact on them. So naturally, I'm not an ecologist. I can't, maybe Jess can give the details of that. Dogs, for instance, when you're walking your dogs, a lot of them will stick to those paths. Some of them, like mine, my spaniels, will be off into the gorse and getting ticks all over them. But the hope with the HSA is that it will be a place where dog walkers will gravitate towards, because it's more of an open space. It's not a destination. It's not very, very pretty, but it's the design of it is enough that people will hopefully go there and use that to walk their dogs instead of remaining entirely on the heath. So it might even help with existing patterns, but we don't know. That's what the management plan is there for. I don't know what are their what are their and any other advice I can give you on that, but I hope that helps.
Thank you. Monica?
Thank you, Chair. I just wanted to add a couple of things. I wasn't intending to actually say anything today. Obviously, I spent on this application at least 2 years, if not more. I've been involved in numerous other applications in the past, and I fully accepted the members of the committee do not accept my recommendations. That's acceptable, understandable, that's their right. I just wanted to reiterate and reassure members that every effort was taken and every scrutiny was taken to ensure that this application is assessed properly. That includes any assessment of the applicant's information, which I accept some people may be thinking is not accurate. That includes the members of the committee. We have looked into everything throughout the process of at least 2 years, including the process of pre-application advice, which has taken some time before the application has been submitted. And the professional bodies, external and internal consultees, have had the right information, the correct information in front of them to make the decision that they've made, the comments, the advice that we've received. That has translated into a report which was presented to you. I understand that you may wish to take a different recommendation and make a different decision. However, I would like to reiterate that the assessment of the scheme has been done to the utmost scrutiny at every possible level. Thank you.
Thank you. And I fully accept what you just said. I don't doubt it for a minute. I'm just thinking hypothetically, I'm possibly going off at a bit of a tangent. The issue of people taking their dog to work and walking the dog maybe in lunch hours or before or after, that they would be working in the area that at the moment is only subject to outline permission. Yes? Am I right on that?
We assume that obviously people will be working.
I'm not talking about the hospital staff. I'm talking about working in the possibly offices, whatever it turns out to be.
Yes, well, the majority of people employed would be working in the outline area of the application.
Which is still only...
It's in outline.
It's an outline, so we don't know what it's going to be. Therefore, we have not looked at it.
No.
When we do, we will be putting conditions. Hypothetically, could a condition be put that they are not, the staff are not allowed to walk the dog in certain areas, say?
Sorry, point of order, personal clarification. I did state that I wouldn't be involved in a debate on items of the material factor, and we're dipping in and out of that at the moment.
We are a bit.
We've discussed the item related to the restricted business, and we're not going to close session for that. Can I just seek advice if we're going to be discussing material items? I should withdraw from this meeting. Ask some clarification from either.
I was just asking whether hypothetically, which, you know, we're not. What I'm saying is we're not committed to what's going on the outline part of the application at the moment. We don't know what it's going to be. Well, I don't certainly. Or what it was, what it would be intended to be if it goes through.
Sorry, Madam Chair, just to reiterate my point of order, I haven't had a response to that. The monitoring officers just indicated
you're listening, you don't need to speak, so you won't be entering the discussion.
I will withdraw at the advice of the monitoring officers. Just indicated that I don't wish to be seen to be involved in this part, the material part of the debate, so I will withdraw. Thank you very much.
Mr. Gould, you had your hand up.
It was just to come back on that point that you've just raised there, Chair, about you know, could you in theory add a condition to the IQ part of the I think what we need to remember here is that we had the decision as obviously the decision making part has now been taken away from the council or the local planning authority because we're at an appeal. So as part of that appeal, depending on what members conclude today on what they want to do in terms of the appeal, we may have to provide a list of conditions, or we will have to provide a list of conditions as part of the appeal process. So in theory, yes, but obviously that doesn't address the more substantial matter, which you know, Mr. Lane has just outlined about.
Oh, absolutely not. Absolutely not. But there seemed to be a concern about dog walkers. Well, that's not set in stone. I mean, you know, we don't know whether that would happen or not, and we could take action probably to do something about it. But that's not. I accept I'm going off at a tangent, and I'm not going to go off at a tangent more.
Chair, the only observations I'd make, and again, I'm happy for my colleagues to shoot me down on this if I've got it wrong from a planning point of view. Well, I'll make a few comments to pick up on some other stuff that's been said. First of all, I think it's important to understand what the purpose of the HSA is, opposed to it's not a SANG. Its purpose is to essentially primarily to offset the harms being caused by the developments coming forward. And as I understand it, that would potentially include people walking their dogs as they go there. So that's part of the reason for the HSA, is to overcome the very harm members have expressed about. Just dwell slightly onto the point Councillor Rice raised about footpaths. Again, it's my understanding, I should be told I'm wrong from my colleagues, but my understanding is the position of the ecologists is that, yes, they recognise there might be a degree of linkage through the existing footpaths, but they don't think that's a bad thing. They would be concerned if suddenly levels increased, as more footpaths suddenly appeared, but they also think that to the extent any harm might increase, then the management plan would give the facilities to address that. So they're not, as I understand it, particularly concerned about that point. That's my understanding. I'm happy to be told otherwise by colleagues around me.
Thank you, Monica.
Thank you. I just wanted to come back on Mr. Gould's comments. Hypothetically, obviously speaking, in this situation, as we are not in the process of actually discussing the details of the outline permission or any application, if assuming the appeal is successful for the appellant and planning permission is granted at appeal, you would, as members, be having a chance to discuss reserved matters application for that part of the approved scheme, which will then give you a chance to discuss what conditions you seem appropriate, obviously relevant and precise enough to be implemented within the reserved matters scheme, which will follow from whatever is discussed at appeal. But
so
I
think that confirms my point that withdrawing that sort of part of the objection doesn't automatically mean that people will be taking that action.
No, that's correct. Yeah. Well, if there's still a mechanism to control certain actions, if you feel it's necessary,
confirmed,
and if you've an account of the day. So, yeah.
Thank you, Francis.
Just to add to that, I'm wondering, it could be that we could condition the detail for the IQ in any no dogs allowed as part of this.
Yeah. So you're confirming what the red herring I was throwing out, which isn't quite so much of a red herring. Anyway, back to the substantive. We need, if we're minded to pursue the appeal, our objections, and we'll come on to that later on, we need reasons that prove that it conflicts with the local plan. So I'm interested in hearing whether anyone's got anything to add, having looked at the local plan, and I realise most of you probably haven't even got it in front of you. It is available on the web. I've happened to have got a paper copy. Is there anything about the original objections, or anything that might be added because it conflicts with the local plan? Has anyone got any thoughts? Is your hand up, Councillor Dunn?
It was, although you asked a different question. I was going to answer a question you asked earlier, but I just wonder if I can put this forward, and I'll see if we got seconded, because it may be the right time. I'm just trying to like move this forward for yourself. I've heard everything that was being said today. I've read the supplementary papers. I absolutely respect everything that we've heard from Mrs. Lane today. However, I can only go on everything that I've heard or seen at the site visit and what was presented to me on the 2nd of October. I haven't had since then any new material information that would have changed my decision on the 2nd of October with the decision that I came up with and how I viewed that planning application. And therefore, I'm still very much minded to be of that same decision on the 2nd of October. Things that have happened afterwards, I think I'm going to set aside. I'm not entirely sure that's for the committee, how the local authority want to proceed with an appeal. It tends to be with them and up to them, although I'm grateful that they're engaged with the committee. But I'm still at all the evidence that I've heard and taken into consideration was up to the 2nd of October, and I'm still minded to be of that same mind. I believe that if we had behaved unreasonably or outside of policy, then the officers we did take legal advice would have provided that information at the time. So I'm quite happy that our decision making was sound as well. So for that reason, I'm going to suggest and propose that we adopt option 10.1 and maintain the position as it currently appears, and would look for a seconder to that point, please.
Right, we've got a seconder, but I think that we need to have more discussion on this. You talked about all the papers you looked at. Did you read the local plan? The Poole local plan from 2018?
Not completely. No,
Right, because that has got to be our starting point. Absolutely.
I haven't read all of those local plans inside out where I can just recite it from the top of my mind.
But there is one section.
Yes.
2 pages.
Yeah.
Not a big deal.
No.
Referring to this specific site. And if we haven't read that and taken it into account, so we haven't got a leg to stand on.
Right. So the question you asked me, have I read the Poole local plan? No. Have I referred to that page that you referred to there? Yes.
Right.
Hope that helps.
Right. More hands. Councillor Sidaway.
I also have the local plan in front of me on my laptop, and I have read it. I don't think any of us don't accept that this building was this site was outlined for this sort of development, but I think we have proposed reasons, and we've offered to strengthen them as to why we didn't like it. It's not because we just don't like it. There were reasons on the day, and the officers present did not overrule us. They did not give us advice that that was not the way to go. The summing up we just got from Wendy, I think, changed the process and basically said that she doesn't believe that we should go any way but 10.3. And I think that's wrong.
I've seen some. Well, Councillor Clements, was your hand up? No? I'm sure I saw a hand over this side somewhere, but I can't see it now. Councillor Rice, was it?
Yes, well, I was just wondering whether I should go through raising some of the other concerns that I raised in my report. I suppose one of the things is I haven't seen anything back with regards to all of those points. It would take a while to go through them all here. Can I have some information as to am I going to get specific feedback on all of those points? Can we all see the information back on all of those points? Or otherwise I can just raise them.
Can you remind us clearly what those points were?
We have already gone through some of them. So another point was about whether there is any planning aspect to the fact that Talbot Village Trust are responsible for managing the HSA in the future. And yet over the last 10 years, sorry, just thinking that over the last 10 years, they have demonstrated that they haven't been able to care for the current heathland that they're responsible for. So for example, they went into a higher level stewardship scheme with Natural England in 2013, and it was agreed that a report would be provided at the end of the 10 years. There is no report for us to see. There was also no interim report provided, which was stated that they would provide. And they were also, in conjunction with ward councillors, they were offered £27,000 worth of SIL funding to improve biodiversity in the heathland, and the landowner Talbot Village Trust refused to accept that money. And even though they were part of this higher level stewardship scheme. So there was some other things, but it's just one exactly. Residents are very concerned about their reputation. Yeah.
Can I ask officers whether this is a point to be considered or not?
So Chairman, just to first reiterate a point I made earlier, which is regard has been had to all the comments that Councillor Rice has provided, and that's where we're at now, but regard has been had to it. If she wants responses to the points, that's something officers can potentially look to do. They can undoubtedly respond to the points that are being raised. Will it make any difference as far as the appeal? Well, I'm conscious the timelines on this, Chairman, are that we have to get a position for the statement of case within the next few weeks. So it won't impact on that. But if Councillor Rice wants answers or comments on her answers, I'm sure that's something officers can look to put together separately. Can I carry on with a couple of other points?
Yeah.
On regard to the resolution that's now coming forward, first of all, I should say that the starting position here is the officer position has always been that this application should be approved. We've gone through various processes and nothing has changed. The officer position remains that this should be approved. And it follows, therefore, that if members want to go against that view, to the matter of members, but as has already been indicated, that does carry with it potential cost implications. But it also carries with it a further issue, which is actually dealing with the appeal, which is ultimately if members wish the council to oppose the appeal, that's their decision, then the council still needs to present its case. Now, because of the officer position that they don't think it can be supported, it is also follows from that officers do have concerns as to whether they might be able to find any other professionals who would be willing to support the council's position. That is obviously something the council will carry on investigating, but it is certainly a possibility that they may not be able to find people who are willing to defend some or all of those reasons. In that situation, Chair, I think as part of the resolution members will be exploring, I'd ask them to identify potentially any members of this committee who would be willing to attend at the inquiry on behalf of the council to explain their rationale. Now, it's fair to warn members in that situation. If they attend, then obviously they'll be presenting evidence, they'll have to use proof of evidence or be of assistance. And potentially in that situation, they would have to be subject to cross-examination by the other side. So I'm just explaining the situation so members understand it. The members do understand there is a consequence of the process that we have to go through. And ultimately, members want to defend this. It's absolutely fine. That's a member's decision. But we still need to then prepare for the appeal and deal with it appropriately. And members need to recognise we might struggle in that respect, but that doesn't mean members can't put themselves up and be willing to present the case on behalf of the council. That's what they want to do.
Thank you. Councillor Canavan.
I think it's important that we just get clarification of where the officers are. Are the officers collectively, any of them, all of them, seriously saying that they're not prepared to defend the decision of this council when this goes to appeal? Because that's outrageous, frankly, because that's what we pay you to do.
I mean, again, to be clear on that point, officers are members of professional bodies, and the professional bodies have certain expectations in relation to those officers. So, and one of the positions is officers have to maintain their professional position, and it would be inappropriate for them not to do so. It's not to say you couldn't put an officer standing there at the committee, at an inquiry, and they could present what they understand the council's position to be, possibly. But to be absolutely clear, if they're asked any questions at that inquiry as to what their professional position will be, they would be obliged to explain what their professional position is. And their professional position, as it stands at this moment, as I understand it, clarify if I'm wrong, is that the application should be granted. So it's not that they can't do it, but frankly, it doesn't help the council's position if they do it. That's my general view.
Thank you. Councillor Clements.
Thank you, Chair. Just following on from what Mr. Firth has just said, the proposed plan was recommended to approve because it met all of the criteria that we actually have to abide by when we are making planning decisions. On the day, the planning committee decided, for their reasons, that they didn't agree and they refused it. We now have to face the consequence of that decision and take responsibility and be accountable for that decision. It's my recollection that on the day that the officers actually asked planning committee to be very specific about their reasoning for the refusal, and they couldn't come up with a very specific reason, and gave it back to the officers and said, oh no, you do that, you take it away and do it for us, which at the time I personally felt was very unreasonable. But we are now in the situation that we are, and we have to accept the situation that we're in. And I've always said, and I still stand by it now, our officers are professional, trained, qualified, knowledgeable people. We pay them to advise us and support us and guide us. And if, when they're giving us their advice and guidance, we decide not to listen to it or take it, we have to face the consequences, and that's where we are today.
But we also bear in mind that there are consequences much broader, not to us personally, but across the whole area. I mean, it was reported to me that the applicant, or somebody to do with the applicants, after the original decision said this this will bankrupt the council. Well, knowing our financial position, you know, while if we have a very strong case, well, for a start, if we've got a very strong case, it will be found in our favour. All the advice we're getting from our local officers and much more broadly from council and everything is that these reasons do not stack up and we would most likely lose any appeal. So we've got to look at that because, I mean, let's face it, if we lose the appeal, it's going to go ahead and we won't have any influence about what happens. If we lose the appeal, it's not only the financial aspect, this will go ahead without any local input on how it proceeds. Anyway, Councillor Dove.
Thank you. I think I'm going to try and move this forward. I agree with absolutely everything that Councillor Clement has said, in as much as our officers are professional. They presented a brilliant case. There's no way we can absolutely not recognise the hard work that Monica put in. It was an exceptionally presented case. The site visit and the day itself run amazingly well. However, we still get to the point of, if we go against officers' recommendation, then these are the consequences. If that's the case, why do we have a committee to hear cases, and why doesn't everything just go through delegated response? So I'm going to go back to where we were. We came to the decision that we came to. I'd like to vote please on 10.1 if we can, unless there's anything else that anyone wants to add to strengthen that case. But again, you know, thank you very much for the officers, but we do have a committee system. We don't always go with the recommendations, and I've understood what you've said, but we cannot make a decision or change our decision because it's going to cost a lot of money. We have to do that material planning grounds. We haven't had any new reasons that come forward since the 2nd of October.
I haven't said we do it just because it's going to cost us money. I'm saying because we will lose all influence and so on and so on. But I'll hand over to the senior planning officer. Oh,
thank you.
Planning.
Yeah, thank you very much. I just need to, again, reiterate the situation that we're in. We utterly accept the reasons that was given. There was a resolution to refuse with agreement subsequent that additional legal advice was sought. That was sought. That is additional information which has been brought in front of this committee. Committee then accepted that and agreed that external expert advice needed to be sought. That has been sought. That has gone then to the exempt information that you have provided. So you have been provided with additional information. It isn't just a matter of you only have the information that was in front of you on the 2nd of October. You have information that shows that the reasons that were highlighted aren't showing that it is not incompatible with the policy, i.e. your decision would not hold up because there wasn't the development plan policies which supported that. I know that you wanted those policies to do that, and that was the articulation again, but we sought external advice to get that checked. And the view is that they are policy compliant. So materially, we have given you what you asked for to try to strengthen those grounds, and the response is we can't. And actually what we've done now as a result of that additional information is highlighted that those grounds are not defendable. So if you do want to go forward, as I say, we have no case to make because we know those policies. We can't make a case on those policies because we have that information that we had already with the additional information that there is no case to make. So that's very much why we're kind of coming through to you today to say, if you need to do that statement of case, we need to have evidence to do so. We can't just have generalised kind of vague views that we don't think it's in line with the policy when we have internal and external experts saying it is. So I just need to reiterate, this isn't the situation purely as it was on the 2nd of October. We desperately tried to get you that robust evidence that was not there to back you up, and it still isn't there to back you up. Thank you.
Thank you, Chair. obviously we covered the PP 32. Is it possible to bring in Mr. Smith to cover PP 35? Just get his view on the over provision of car parking, please. Thank you.
Yeah, just to remind members, perhaps just going back over it. Yeah, the under our parking SPD, the hospital element of the proposal, our park SPD seeks an optimum provision, which is an ideal provision of about 130 spaces. The proposal came in for the hospital element at about 195 spaces, so approximately 60 more than our SPD gives us as an ideal. Just to outline, the SPD isn't a minimum, isn't a maximum. So we have multiple developments approved by this planning committee which have had an over provision to that SPD, and the SPD does have a flexibility for developers to come forward with a parking provision that they consider is appropriate. From our point of view, the applicant put some evidence forward as to why they thought the over provision was appropriate. Some of that evidence was related to other hospitals that they operate. Also, they put forward that in the consultations with local residents as well, there'd been a concern from residents about the parking provision being too little. So bearing that in mind, and again, we got significant mitigation measures put forward, over £300,000 for new bus contributions, a cycle lane, etc. From our point of view, in terms of our highway remit, we accepted that the over provision was justifiable, and particularly, as I said, given many other cases where the local planning committee had approved over provision of parking. So it's about 60 spaces more. There is one other element I would add. It does actually remove, the proposal removes his 41 spaces from the university as part of the new access road. So actually, if you took that into consideration, it is removing some parking. So then you'd have an over provision for 23 spaces. But just taking this application as the hospital on its own, it's 60 more. Just going to the outline permission. So the outline for the business park is only outline. We don't have the detail. They did submit a master plan to give an indication as to the parking provision, and that parking provision, if it was considered offices, the business park would have actually been compliant with the SPD. But the outline could have a condition on it anyway, saying parking shall comply with the SPD standards. But in terms of the detail, roughly about 60 spaces more than the SPD. Hope that answers some of your questions, Councillor.
Yeah, that's very useful, Mr. Smith. Could it, obviously you said it's sort of guidance, it's flexible. So yeah. Has it been tested with an inspector in previous applications where flexibility either way is allowed in the spec? The inspector really recognises, well, yeah, it's a hospital. It's a private hospital. There might be more people driving than public transport. And as you said, allocation taken from another area, allocated here, in the round, it's all about the same.
Well, we haven't had any appeals I'm aware of in respect of hospital uses, I would say. So we've no sort of back history with regards to hospital uses. Where we've had development approved where there's an over provision to the SPD or refused and it's gone to appeal, we've never refused anything for an over provision relating to a specific development, as far as I'm aware, and planning committee haven't. And if those developments have been refused for other reasons, such as appearance or mass and bulking, the planning inspectorate, as part of the appeal process, consider all the factors, including the parking provision, whether the authority objected or supported that. And we haven't had an appeal case where an inspector has come forward and said, yeah, I note the refusal reasons for planning, etc. But I also they've considered adding in a reason because of over provision of parking. The original SPD, when it was presented to full council, the parking standard SPD, there was a question raised at that full council. I did listen to the debate about whether it was a minimum standard or whether it was a maximum, and the response from the promoters of the SPD, the councillors involved at the time, said it was to give flexibility, but there would be this element of developers submitting why they think it should be over provision. And from our point of view, we considered they'd submitted sufficient justification.
Just come in.
Only Chairman, again, I think I'm conscious we're trying to move this further forward. We obviously have a resolution on the table today, all three. But in that context, I think it's important to emphasise and take on board what Director of Planning said, that officers at different the strength of officers' concerns relating to each of the three reasons that members have originally identified are not necessarily the same. They have concerns of different degrees in relation to each. Now, picking up a point made a long time earlier about whether it matters as to whether or not you should have one strong reason or three weak reasons or whatever it happens to be, in number terms, there is a difference. And the difference is that at an appeal, setting aside that costs can be awarded against the council just for acting unreasonably, setting that aside, an inspector can award and make an award of costs in relation to each reason that you put forward. So in other words, it's what's called a partial award of costs. So even if an inspector felt you were reasonable on one point, then he might conclude you unreasonable on other points and award a partial award of costs. Now, I make that distinction, Chairman, simply because at this moment, there are three areas of issue that members have identified, which stems from their original decision on October the 2nd. Now, I'm just wondering, and I throw this out really, and as much for the person who moved and seconded as anything else, but I offer it up as a thought, as to whether it might be beneficial to take almost a vote on each of those reasons, so members can to say whether they want to, yes, that's the reason they want to stick to, or no, it isn't, because as I said, it might make a difference as far as the individual situation is concerned on awards of costs of strength or otherwise. Chair, I want to say one other thing, and I think it's important because it's been raised in various guises as to the process, as to why we are where we're at. It's identified in the report, but I want to say it, that in my view, what's happened before has made no difference to where we are now. We were always potentially going to end up in this situation, in my position. Had members refused the original application and decision notice being issued on the basis of the three reasons identified, there's absolutely nothing to suggest otherwise than the appellants would have gone to appeal. So we'd have been in exactly the same situation. Whether we get to an appeal through an appeal against a decision notice or we get to an appeal for non-determination, we would have got to an appeal. And the process of the appeal is exactly the same. Jurisdiction passes to the Secretary of State as appointed inspectors. Now, as part of any normal appeal process, officers would still investigate the reasons for refusal that members had identified and would still carry on the discussions and exploration of those issues. And if we thought there were issues, we would potentially be coming back to members and say, well, actually, we've now looked at it further and we're concerned about them. So I know there's been concerns expressed about the process to get here. In my view, we were always potentially going to get to this point because of the starting position of officers and because of concerns over the reasons for refusal. But Chair, focus on that, on what I said earlier. Question mark, would members like to look at each of those reasons they identified originally separately? And I would still come back to the earlier point I made. If members still wish to proceed with this, can they also give consideration as to whether any of the members in this committee are prepared to present evidence at the inquiry to assist the council?
Thank you. I think that's probably a very sensible suggestion. So, Councillor Elliott.
Thank you, Chair. So we haven't really looked at the green infrastructure. So again, if Mr. Martin, looking at it, so a new development should protect and strengthen the green. So connecting together to enrich biodiversity and wild habitats. When I went to a site visit, we all saw there were fences, obviously the urban farm, whatever, there was fences. So this new application would be taking fences away. Improving connection between corridors. Again, there was different elements of the site, which again were fenced off, whereas this application seems to link it all together. Is that correct, Mr. Martin? Is that your interpretation? Thank you.
Yes, that is correct.
That's all I wanted to hear. Thank you. And just if we take a step back, there was mention that more, going back to 32, that more people might be attracted. Have you had, I imagine you must visit the site and manage it with Talbot Village Trust quite often. Have you had numerous increasing footfall and incidents and arson and things like that?
Over the several decades I've been involved with the council, there has been an increase to numbers of people going to the general Talbot Heath area, including some people going onto the proposed HSA unofficially. The amount of arson generally in the BCP area is less than it was in the 1990s, both on Talbot Heath and even in the 2000s, whether it's at Talbot Heath or in Bourne Valley. So and it's because of actions by us and others on education and the fire service and the police. But fire is always a risk, but also as part of the management plan for the area, they will be looking at doing management work on the site to reduce the fire risk.
And just talking about that management, so there's been mention that the management of TVT has been poor. Do you work with them, and do you make recommendations? Are you happy?
No, well, that in relation to the high level stewardship agreement which TVT have for their land, that is on the purview of Natural England. So any issues on how that land is managed underneath that needs to be addressed to Natural England. We do have cooperation with Talbot Village Trust in relation to grazing the area, because we have in summertime some of our cattle grazing top beef, which is basically grazing some of our land and also some of our Talbot Village Trust land. But
And
as
just
to,
lastly, just lastly, there was mention that Natural England changed their comments, etc. So you mentioned there, obviously they work with TVT, so people from Natural England would be visiting the site, so they would know the steepness of it and the gradient, etc.
So the Natural England's was a sponsor from Nick School, who's knows this site for many decades, so is well aware of the access and the terrain. The high level stewardship agreement is managed by someone different in Natural England, but he knows the site better than anyone else in Natural England in the local team.
That's appreciated. Thanks.
Thank you. Thank you. So shall we look at the 3 reasons for refusal?
Points of order, Chair. You have a motion on the table which has been moved and seconded. If you want to take that vote separately, then somebody needs to move and second an amendment.
This is part of the discussion that will lead to a vote on the proposal, so that we've got a chance to look at, because the proposal 10.1, maintaining the position as currently appears, albeit possibly with certain clarification, which could be addition, we've talked about that word, relating to the reasons. So if we're looking at the reasons first, that will clarify whether we want to go with number 1 or not.
10.1 maintains all the reasons that we agreed on the 2nd of October.
But with the possible clarifications and additions, that's the bit.
Yes, but we're not going to go through the recommendations that one at a time that we've already agreed, because we've already agreed them. What we're looking at is whether we want to add anything, isn't it? There's no point in going over the decisions we've already taken.
Some people may feel that what they've heard and read in the meantime have affected their thinking. This is to give an opportunity, should that be the case, in either direction. Could be.
They can vote against and put forward option 2, but at the moment we're discussing keep the ones that we have and see if there's any extra ones that we need. That's what's on the table.
Okay, we'll do that then. So the proposal is that we go with 10.1.
Just check the device. Just check.
Yeah. Any
professional?
Any comments on that? I was just going to put the proposal.
Yeah, I mean, sorry, I should say.
I was aware that there were discussions going on.
Sorry, what I mooted, Chair, was simply an option if the mover and seconder wanted to take a different approach. Mover and seconder doesn't. So yes, members are perfectly entitled to vote on 10.1 if they want, and if that fails, or indeed someone can propose an amendment now, or they can. And if it falls, then members will be left with something else. I mean, Chair, what I should also say is the 3 options there, they're not meant to be all-encompassing. It says these include, so there might be other options members wish to pursue, but they want to vote on 10.1 now. That's a matter for members.
So,
but Chair, I would say, come back to my point, which is, I would ask, we need at some point members to also decide if anyone's going to be prepared to stand up at the inquiry.
And if 10.1 is passed, my interpretation is, I stand to be corrected, that it rules out 10.2 and 10.3.
I've already made that point, Chair, that they're not mutually exclusive in my view. Like to put it down to a binary position like that is just not acceptable.
And to be clear, I'm not that they are not binary. That's the point I made. These are not absolute reasons for it. This is not the only three options available to members. Members can play around with it if they want to.
But to vote for option 1, surely that, well, it certainly excludes 3. Does it exclude 2 as well?
Well, I think what as I understand the resolution, and let's perhaps we just focus on what the motion is. As I understand the motion is essentially proceed on the basis of 10.1. That's what I understand the motion is.
Yeah.
So once you've voted on that, which is maintain the position as currently appears, i.e. the appeal should be dismissed for the reasons identified in October 20. That's the motion. Members are, so as far as I know, no one's proposed any clarification to those reasons. That can be debated before you make the vote, but I'm not aware anyone's proposed clarification. I know there's been some discussion on it, but nothing's come forward. And ultimately it's for the mover and seconder, I suppose, to amend their motion if they wanted to in view of the discussions. But at present, absent any clarification, members vote on 2.1, you'll be left with the 3 reasons that you originally identified. That's I understand the position.
So, Councillor Rice.
Mike?
I just have one suggestion to add into that proposal before as an option for, well, to add in. So it's policy PP21 2B, page 75 of the pool local plan. So it says that all proposed developments, growth at Talbot Village will be carefully developed to deliver an innovation quarter on land at and around Hallingmore Farm, comprising 25,000 square metres gross floor space to help support the role and function of the universities, and comprising a mix of B1 uses, healthcare facilities and other university related uses. Now, I put this in the documentation, but initially I read this differently from how I now read this. So this is why it would be useful to get legal clarification, but I do not read that as a private hospital is supporting the university. So everything should help support the role and function of the universities. And that can be through a mix of uses, but that is not what a private hospital does. So it does not fit with policy PP21 2B.
So, thoughts?
Jim, while the planners consider that, I'll just make on the procedural point, obviously, depending on what members decide, that will be up for the mover as to whether they take on board the amendment that's being identified. Chair, sorry, I just want to say one other thing as well, which just occurs to me. Of course, we keep on talking about the reasons for refusal, but what we're now doing is really identifying the areas that members would wish to be presented at the inquiry for the reasons why the council think the application should be resisted. Because it's not reasons for refusal as such, because there's no decision notice that comes out of it. But these are essentially the areas that members would wish officers to focus on in trying to defend the appeal. That's give my colleagues time enough to point on me.
Thank you. Just to answer the concerns on PP21 2B. So this is basically a mix of uses supporting the universities. I can draw members' attention to point 739 of preamble of policy PP21, which says, I'm going to quote this, if you just give me a second. Mix of uses should therefore include B1 with a particular focus on ICT, creative digital industries, environmental technologies, biomedical and healthcare facilities, a private hospital or a care home, for instance. Other ancillary uses demonstrated as necessary to support the social and business environment functions of the innovation quarter could also be appropriate, i.e. conference, meeting, academic space, cafe, coffee shop, etc. So I believe that answers the question whether the private hospital meets the policy criteria. Thank you.
Well, yes, initially it did. But then on reflection, I'm wondering whether that 7.39, which is the bit that you just read out, overrides the bit in purple or pink, the actual policy. So that is additional information, whereas I think the actual policy is the thing that we have to stick by in the...
That would be the interpretation of policy. In my professional view, it doesn't, but that's my view, and obviously members are entitled to their own.
And it conflicts. So we've got a local plan that conflicts with it. So.
Yeah, thank you, Chair. I think this point was drawn out in the debate in October, actually. And I think the response at the time was that actually the university provide courses that feed into employers like the hospitals, such as midwifery. So there is a tangible link between the university and the businesses or the hospital.
Yeah, there wasn't much in the report about the actual link.
It's definitely covered off in the discussion in October.
It was definitely. See more hands at the moment.
Chair, so in view of that, I think we have to turn to the mover and say do they want to take on board the point. But the officer position obviously is that it's not necessarily a strong point, but I don't know if the Councillor Dove wants to clarify.
I apologise greatly, but I think we have to there understand almost like the subsection that sits behind. And I know it's not officially a subsection, but it informs that policy. And for that, I don't know if I would be able to adopt that additional one, but happy if someone wants to make it as an amendment, we vote it and it becomes a committee decision rather than just me. It's everyone's interpretation of it, isn't it?
Chair, can I just clarify what it is that the committee is being asked to vote on? So am I correct, Councillor Dove, that you are refusing to accept the proposed amendment from Councillor Rice? So therefore we're back to the original intention of your motion, which is seconded, which is to vote on paragraph 10.1 as detailed in the report. Can I just clarify that?
Just let me just check with the seconder what they're happy with, because I just want to try and get this done as streamlined as possible and then make sure we've not got too many tangents going on. Seems like lots of pieces of wool and string at the moment.
Well, I you know, for the sake of repeating myself, the words in 10.1 with certain clarification, I'd already made that point, that if that allows us to in any way strengthen, add things, change things, then that's what we should do. What the point, in my view, and the reason why I'm supporting 10.1 is because that offers us the strongest position if we're going to defend this in courts. Let me just say one other thing while I can. If the strength of view of officers is so strong, then why don't we have a recommendation in front of us to refuse this application? We don't. And yes, it was in the original. Of course, it was in the original proposal. But you know that we've been through months of this, and the point has always seemed to me is that what officers really, you know, if they were candid, wanted to do was to get us to change our position. Why haven't they said that? Because they haven't. Now, you know, my view.
It's 10.3.
It's an option, Chair. It's not a recommendation.
So back to my original question, Councillor Dove, I'm still not clear. As the mover of the motion to vote on the wording of 10.1 as detailed in the report, are you willing to accept the suggested amendments from Councillor Rice before a vote is taken or not? And do you wish to amend it to incorporate the views of Councillor Rice or not? I just need to be clear so that the members of the committee know exactly what they're being asked to vote on and you have clarity around you.
So we'll vote on the amendment and then see how that goes and then see if we have a standard thereafter. That's okay. That seems the best way to proceed.
Well, Chair, I'm not sure there is
an
amendment yet, but
I can put forward an amendment.
Councillor Hilliard.
Oh, so all I would say is, so anyone who's voting on this 10.1, as the officer brought up earlier, I hope you're all saying that you're willing to go to the inspector and talk to the inspector and support your views, because as Councillor Caravan saying, the officers have clearly stated that their view, they've tried to work with finding support for your objections in their professional capacity and the professional capacity of others. They haven't been able to say fully support, and that will be tested by the inspectors. So what the officers are saying is that you will need to step up and be at the appeal to back why you think, as we just covered with this PP21, its interpretation, and you will need to give your views. Thank you.
Yeah, I need to add, I need to clarify what it is that we are proposing. I'm not proposing we are getting bounced into legal representations at appeals or anything else. I've given my reasons to why I feel 10.1 should remain, and that's because I listened to the evidence that was provided up to the 2nd of October. There is no further material planning information that I've had in terms of evidence. I know we've had some, so you're frowning at me, but there's been nothing that has come forward in terms of that would make me change my mind, because I've heard what the officers said, and on that basis, that's the decision I made on the 2nd. That does not mean that I get bounced into further litigation or anything else. I was asked to attend as a committee member and vote on what I've heard on that day. Having said that, I really think we should go to the vote, please. But that's the remit in which I have made that proposal.
I'm working towards that. Councillor Salmon's got her hand up.
I have not suggested anything else and further actions on behalf of any member here as part of that proposal.
Councillor Salmon.
Yeah, thank you, Chair. We've just sort of trying to do two things at the same time, which is really difficult. So ages ago, Mr. Firth asked us members to comment on whether they'd be willing to go to the inquiry. I've been trying to ask a question on that for ages, but we keep going on other things, which is, you know, it's difficult. We're dealing with difficult stuff. So I can't, and then Councillor Hilliard just brought that back up. I'd like to ask a question on that. May I do that now? Or do we need to go to this vote on this amendment now? Okay, thank you. My question is, if a member of planning committee is willing to take part in the inquiry, are they able to seek support from what's the situation in terms of our status as members of planning committee and needing to stay out, usually outside of sides of things? So if we were to go, if somebody was from the committee was to go to the inquiry and was to talk to people who also object to this application, who are not here, would we be doing anything wrong, or getting ourselves into any trouble? That's my question.
So Chair, the process is this. In a situation such as this, where you have a member decision which is against officer recommendation, and just to be clear on the point made earlier, the officer position is that this should be approved still. That's the advice. This should be approved. So if you want to clarify the decision of officers, that this should be approved. But that aside, the process is this. If members decide to refuse it, then the council will still need to prepare for the purposes of the inquiry. Now, often in an officer overturned situation, more often than not, the council will look to see if it can get external advisors to assist it in presenting that case on behalf of the council, because they carry with them the professional expertise to be able to do so. The concern with officers here is that might be a challenge to do that. In that case, there are only two practical options. I think officers could basically try and explain the position, but we all have explained that the situation with that is problematic because officers have to give their professional advice. In the case of members, well, members would then be appearing on behalf of the council, and they would get, to the extent it was possible, the assistance of the council in preparing their case. And that would include, if we end up instructing counsel, assistance of counsel to assist in that case, and they produce a proof of evidence, and how they collate their evidence to support that is in many respects a matter for the member. But yeah, I don't see a problem in that scenario why there's an issue, because you are essentially being called by the council. Now, I should emphasise that how we end up doing this is something we will obviously have to reflect upon as a result of what members decide. So that's something that we'll follow. But I think at this stage, we need to know if there are members who are prepared to do it. So if it's considered appropriate, we can come and ask them.
Okay, I'm very happy to say that. Thank you for that really helpful answer. I would be happy to go to the inquiry. I think I hear everything that's been said, but taking everything into account, I think we should uphold the refusal that we put forward, and I am prepared to stand up and put my money where my mouth is. So yes.
So, I want to get to the vote.
I know. I want to ask a question, because I think what perhaps some of us are struggling with, at least I am, is that we have found genuine reasons why we think it doesn't comply with the plan. If what you're saying is that they are not significant enough, then, and that may be where we can't go, then I think that's something that we should debate before we vote, because in one half I could vote for this motion, and on another half of me, I'm going to vote against it. So I think we can get some clarity around the significance of them, and that might help us looking forward at other ones, because there are plenty of cases we look at where we say, oh, PP21 this, and we say actually just one of them on their own is not significant enough. That's actually quite important information.
This is so much more of an application than most of the ones we look at, that there'll be some feed over, but not entirely. But I don't know.
Yeah, I'm just thinking. So I said we have to be careful, and I think we're already greying the lines quite a bit. I think if members are now of the opinion that they would benefit from some legal advice, then if someone wants to move into exempt session, then obviously they could have the benefit of that legal advice if they feel it would assist them in finalising their decision on this particular vote. But that's a matter for members to decide, and they have to decide if they wanted to remove a situation that, like, as life has moved on, they've obviously had a lot more debate, and they might think, okay, circumstances have changed sufficiently to mean we would now like that assistance. So if members want that assistance, it's unusual, but I think it's possibly open to members to still move into that position should they wish to do so. I'm not sure there's much else I can say on that.
Thank you.
Yeah, no, I don't want to obviously lengthen this, but I think I was fairly upfront. That we think, whilst we respect the responsibilities of members and the views that they hold, that there may be occasions where the prospects of success are so bleak that the better course would be not to defend. We are, as far as office is concerned, in that position. We can't see how we can make a statement of case that would be sufficiently robust, we consider, with the policies that have been given. Therefore, we've sought that additional advice that is available, obviously, as the restricted item. We are still in that position that we can't see how a statement of case can be made. That's why we've just had that side discussion around, because officers can't see that statement of case, can members confidently say that they can? And we are now fortunate enough that a member has said that they feel that they have, with support, sufficient willingness to maintain that. So that's very much so. We as officers saying we can't see the case from our professional views, with our understanding of the development plan based approach and the compliance with those policies, but you now have an additional resource available to you who can see a case. And that's why I think why you're moving your consideration if you don't want to go into exempt. Thank you.
So, Councillor Sidaway, do you want to pursue more legal advice and therefore go into exempt, or have you heard all you need?
I haven't heard all I need. That's for sure. I think that's going to take a lot more for us to get up to speed with why reasons that something doesn't meet the pool plan can still go through. That's a much bigger debate, and I accept the fact that this is a complex, very large application, and that's possibly why. I don't think there's a mood in the room to go to into the exempt session though.
Thank you. Right, so we're back to the motion and the amendment. So we'll vote on the amendment first. So can we have the wording of the amendment, please? Or has the mover of the proposer of the motion accepted the amendment?
Chair, can I just be clear? Because I think Councillor Rice put forward an amendment. I'm not aware it was seconded. Councillor Dove, I think, has remained of the opinion that she wasn't accepting it, but we don't have a seconder for the amendment. So therefore the vote, Councillor Salmon just has. So therefore, perhaps before we vote on the substantive motion put forward, the committee is now asked to vote on the proposed amendment put forward by Councillor Rice, seconded by Councillor Salmon.
Sorry to interrupt, but I don't think Councillor Rice actually got the opportunity to put the amendment. She sort of indicated that she would, but then it was someone else who spoke over her. So I think that's why we were. Sorry.
Does she want to clarify? Does Councillor Rice
so I
just
can
want
put
to clarify?
So that is adding in policy PP21 to B as one of our reasons for refusal.
And Councillor Salmon, do you second that?
I do.
Chair, I think it's now appropriate to have a vote on that amendment.
But for myself, I want more clarification about what you mean by 2B. I mean, what element, what particular?
Well, that was the discussion around interpreting the documentation as to the policy says it should support the university. The small wording says mentions a private hospital, but actually there isn't evidence that that actually supports the university functions. And the main priority for the development of that land is to support the university.
Okay, so the amendment is that we include 2B on the basis that any development must support the university, and the suggestion is that this doesn't support the university. Help support the role and function of the universities. So those who wish to add that amendment to the proposal from Councillor Dove, seconded by Councillor Canavan, will you vote in favour of it now?
1, 2, 3, 4.
Those against, vote now.
1, 2, 3.
And those abstaining?
1, 2, 3, 4.
So that does get added to the motion.
Well, that becomes a substantive motion now,
Yeah.
Chair.
So now can we have the wording of the full motion, please? Councillor Dove, can you give us the wording of your motion, please, now?
Now becomes the substantive motion moves over to Councillor Rice because
Sorry, I didn't know what you meant by
the amendment has now superseded the motion. And I think
I thought this was an amendment to the motion.
Yeah, this is just an addition into 10.1.
yeah, so as I understand, yes, that's right. So as I understand it, it's now a motion for along the lines of 10.1 plus the additional issue reason identified by Councillor Rice.
Yeah. So can we have the wording of the motion? I keep asking, please, from whoever's got it. Have you got it, Ms. Holiak?
So it's to move that maintaining the position as currently appears, i.e. that the appeal should be dismissed for the reasons as identified at October 2023 Planning Committee meeting, albeit possibly with certain clarification relating to the reasons and with the addition of PP 21 2B in that the application is not compliant with that element because a private hospital does not support the university.
Thank you. So those who wish to support that motion, please vote now.
So 1, 2, 3, 4, 5, 6.
Those against, vote now.
1, 2, 3, 4, 5.
So 10.1 has.
Is there an abstention there?
We're 11, aren't we?
11?
Oh, 11? 1, 2, 3, 4, 5.
We are.
7, 8,
Yeah, I beg your pardon.
11.
Yeah, that's right.
So those figures are up. Yeah.
So that carries.
So that has now been passed. So that becomes the policy of this committee. Where do we go from now? 10.2.
No, I think that's
We don't know it. We don't need. Yes, that's what I said. It rules out the other two, doesn't it? I said that before, but nobody sort of seemed to agree with me. So that is the decision of this committee. Do you wish to add any further reasons to those already, the original three plus the one in the amendment, or to strengthen them?
I think that's it, Chair. That's it. They voted on the basis of what's in.
Yeah. Well, it says albeit with certain clarification. Well, that's it.
But I think that there was no other clarification. Essentially, what was offered was the extra clarification, the amendment.
Right.
So, Chair, so obviously we'll be in touch with Councillor Salmon potentially.
I mean, I presented several things earlier in the meeting that have been put forward by ward councillors, which I felt could strengthen our. I know the opposite position. I understand the opposite position is that none of this matters because it's all wrong. But given where we are and what the committee have decided, some of those things that have been put forward earlier, do they not get put in as you know, is this the point at which we do that, or does it not matter? Because we can add things in later.
I mean, potentially, Chair, trying to think on my feet here. I think we can probably pick up issue later. I mean, my preference certainly would have been made clear the position of members now. So I guess if we can clarify what those points are, and I don't like doing this because we've already voted on it. But I guess if there's a confusion over the vote.
Sorry. My understanding is because we are not determining this application today, what we are doing is we are making those components for the statement of case. So clearly you have just voted that you want the statement of case to be produced to be those 3 reasons as discussed on the 2nd of October plus this additional reason. That's the statement of case that will have to be developed by officers in combination. If further clarification had been sought, that should have been sought in relation to the amendments of 10.1, which is what the questions were happening earlier. So we are where we are with 10.1 being those 3 reasons plus that additional. Thank you.
Chair, I agree with the Director of Planning to set a summary of the position that we are now in.
Yeah. Okay. So this.
I don't want to prolong this, but I did want to thank all the officers for their hard work. I know they've in the background, there's been a lot of work into this, and I'm sure if everyone agrees, so just echo our thanks to them because it's not been easy.
Absolutely, they did sterling work. Unfortunately, I don't think it's out of order to say, unfortunately, they didn't convince the majority. So obviously the appeal will now go ahead. It's up to the inspector, the inspectorate, to confirm timings and details, and up to BCP, I presume, to locate a venue. So, sorry. So, with that, thank you everybody for your contributions. Thank you particularly to the officers, both the planning officers and the legal officers. The meeting is closed.